once the investigators analyzed the evidence and the approach that they took in terms of determining any irregularities relating to legal practitioners, they looked at the number of briefs the legal practitioner received, the payments as shown on the basic accounting system, and information gathered from various interviews held. So they came up with a number of about 20 legal practitioners that were fitting those focus areas that we are making, and the investigation so far has revealed various irregularities. I'm gonna scroll down. As the chairperson indicated, the contents of the slides are pretty much the same as we presented in Feb. So we are focusing on the extreme right, which is the progress since the last time we appeared at the committee, which is in February. As you can see, that this is Advocate A, and the evidence so far revealed a measure of collusion between this advocate and some of the members of the state attorney's office. So based on this, there is a various number of referrals that we will make based on the first slide that I presented. We are going to be making a referral to the National Prosecuting Authority, and that is based on the evidence that we found pointing to criminal act. We also referred this advocate to the Johannesburg Bar, and to date his membership has been suspended and until the matter is finalized. There's also a referral to SARS, and there's also an aim to refer to the Special Tribunal. Third line from the left indicates the value which this irregularity and collusion has cost the state, just about 34 million. So the progress is that the investigating team, we have appointed the tax bill consultant simply because we need to make sure that the quantification is accurate. And the tax consultant will verify all the figures as indicated in the line that shows the value of the matter. We are expecting that this tax consultant is going to focus on all the legal practitioners, as we indicate on the extreme right, advocates A to I. So we are expecting that his work or her work should take about 3 months. It could be less because we would like this matter to be finalized as soon as is possible. So, Honorable Chair, this update relating to Advocate A on the extreme right applies to all the advocates that follow from A to I, which is slides 6 to 14. So if I page down, it's Advocate B. It's similar findings. The value there is about 22 million bucks, 22 million rand. Excuse me. The collusion also with the offices of the state attorney. That we're going to be making similar referrals, and we expect the tax consultant to proceed as indicated. Advocate C, it's similar findings, Honorable Chair and Honorable Members, without going into detail. As you will recall, the investigating team here has actually been approached by this advocate after the commencement of the investigations. He has approached the investigating team with the offer to pay whatever it is that could be irregularities. We are still quantifying the value related to this advocate, but as I indicated at our last appearance, we will not rush into accepting offers to pay simply because we would like to go deep, dive deep into the details of the irregularities. More often, when we accept the offer to pay, it could be there could be some line there that says this is a final settlement and so on and so forth. We do not want to run into that trap. We would like to hold him or her accountable for all the infractions that he is accountable for. Advocate D is it's similar. We are also still quantifying. There's advocate E, and there's advocate F. It still shows the similar irregularities, and the progress it's similar as I indicated above. Advocate G and advocate H, and this takes us to advocate I. As you can see there, it's up to advocate I. We are showing that there's overcharging and collusion with officials of the state attorney. We have found a rampant collusion, and there's some of the officials that we have pointed out in terms of the evidence pointing to them. So we are going to be instituting referrals so that actions can be taken. Come to slide number 15. These are the attorneys, but they still fall within the legal practitioners. These are the attorneys that we have also found that they have made some irregularities. Attorney J and K. In this instance, we have already made referrals. You can see there on Attorney J, there's tax fraud that evidence has revealed. On Attorney K, there's also fraud that evidence has revealed. On the extreme right, we have made referrals on Attorney J in June. I've asked the team to be ready with the exact date, should we be required to state it. On Attorney K, we've already made referrals. On all of those, referral to NPA, referral to the Eastern Cape Legal Practice Council, referral to SARS, and we have also made referral to the Solicitor General to restrict the attorney in terms of the practice. And we are also going to add on another outcome, which is to refer to the special tribunal. The last one on this legal practitioners is again an advocate who is in the Eastern Cape. But again, in this one, there's some referrals that we have made. There's evidence pointing to fraud. The value is there to amount of 331,000. In this case, for referrals to NPA, what we do in the referrals to NPA, we compile the evidence pack, and when we make referrals, and it will come through in the mechanism to cooperate with NPA on how do we do these referrals. So the investigating team on the extreme right, is still compiling evidence pack, which we are anticipating will be sent in this month to the NPA. A referral to the Eastern Cape Bar that has been made, and the referral to the Solicitor General has been sent in June now, just so that action can be taken. This, Honorable Chair and Honorable Members, this up to Advocate L, these are the legal practitioners whom the investigation has so to date focused at, and you'll see there they add up to 10 advocates and 2 attorneys up to now. There's 8 more because we've said we've identified 20. There's 8 more that the team is still looking at, but this 20 is pretty much those where the assessment has shown irregularities. There could still be more legal practitioners coming on the radar screen depending on the assessment by the investigating team. On this Advocate L, the referral to NPA is underway, will be made in July 2020 once the evidence pack is finalized. Referral to the Eastern Cape Bar is done now in June, and the referral to the Solicitor General was done also now in June. The next slides, Honorable Chair and Honorable Members, we also reported on at our last appearance. These are slides 17 up to 19. These are the court judgments that were made in the Eastern Cape. So as part of our investigations into the Office of the State Attorney, the proclamation was signed off following the secondment that we had made in conjunction with the Department of Health, Provincial Department of Health. So the secondment work is now feeding into the proclamation investigation. So the secondment work has made substantive findings relating to the Office of the State Attorney in the Eastern Cape and the irregularities relating to some of the legal practitioners and how that collusion resulted in these judgments being given. So the assessment of our team is such that these judgments should actually not have been granted or given had the state attorney done its work properly. So as a result of this, we are already at court, and as you can see there, on the first one, the date of hearing was in May, but due to COVID-19, the date will now be rescheduled. So we have already filed the papers. We would like all these judgments to be rescinded because we are of the view that they do not serve public interest if they are to be left unchallenged. The second one, it's the same on the extreme right. If we focus on progress, it's the same, that the court date was given, but due to COVID-19, the courts were disturbed, so the court date will be rescheduled. The third one, SIU will file and serve the heads of argument and apply for hearing date by June. I mean, June is almost over. I'm here with the chief legal. We would like to make sure that either that deadline is met. If I scroll down, the next case, number 4, on the extreme right, the progress to date is that the matter was enrolled, but it's going to be rescheduled due to the court schedule being disrupted. Number 5, we will also apply for a hearing date showing there in June. We'll have to verify with the legal team such that we met that date or not. Case number 6, it's same as the one above, where we'll apply for a hearing date. Case number 7, the same. Case number 8, this is where the case is already in court. The department had already taken it there, so SIU is evaluating whether to join the case or not. But based on my observation and the experience, we are likely to join the proceedings so that we can bring our part in court. Now, the next slides, Honorable Chair, and again, we presented this at our last appearance. We now deal with those officials in the State Attorney's Office. It's about 7 State Attorney officials to date. There could be more officials that come onto our books because the investigation is ongoing. These are the officials whom evidence have indicated that they've, in one way or another, colluded and caused the damage and the cost to state. For these officials, the investigation is still ongoing just to ascertain the extent to which they were involved in the collusion and what is it that they've benefited. And you could see there that amongst others, the investigating team is conducting the lifestyle audits and the disciplinary referrals will be made anticipatedly in August. And the referrals in the column number 2 from the right, similar to to the outcomes, as I started with the first slide, we're going to be making referrals just to make sure that the consequence management is similar, disciplinary referral, criminal referrals, and civil recovery through the special tribunal. That applies to all the officials, officials 4, officials 5, officials 6, and then the next slide, the slide that's appearing now, we do find that there's other officials that are not employed by the Office of the State Attorney, but the investigation leads us to those officials in the collusion process, so to speak. Who colluded with who? The investigation leads us to all those. You can see that there's even a NES that has been identified as having played part in this collusion process. In number 2, there's also an official of the High Court. There's also an official of the High Court whom evidence has pointed that he or she is also involved in this irregularity.
All those.
And
you can see that
we will make referrals once the investigation is complete, once we have quantified the extent of the involvement, and we know the value that they have prejudiced the department by.
In number 2, there's also an official of the High Court.
There's also an official of the High Court whom evidence has pointed that he or she is also
when I checked the slide
involved
in this irregularity.
All those. And I indicated we will make to the referrals to the team that the heading there may not be appropriate because this official is, and we know on the next column from the left, you see that this official is employed by the Office of the State Attorney. So they're not employed there. We should really apologize for that, Honorable Chair and Honorable Members. It should be employed by the Office of the State Attorney. So which brings us to about the state attorney officials now. But as I said, the investigation is ongoing. We will be pointing out further officials should be, so they're not employed. The next slide really as we presented, it should be employed by this was done, the proclamation was amended because of the allegations that we received the irregularities relating to the South African police and the unlawful arrest that originated and that has led to prejudice the state. Next slide, the investigation is really pretty much ongoing. The investigating team has received a number of falsely allegations. You can see on that slide, in every state, there's a number of cases received up to 2,571. And the number of cases identified now after assessment by the team is about 227. And the amount that has been quantified to date, just over 50 million. And investigation is the investigative team is doing a number of requested assessments, and the investigation is also the number of all the cases and the number of identified amount assessment by the date with information from the northern case as well related to the allegations in this aspect. We also received allegations from Popo, we also received allegations from Malawi. We also received allegations from the Eastern Cape. So the investigation is continuing, but as the portfolio committee noted at our last appearance, we would like to make sure that we progress as well. As as possible, obviously without compromising the quality of the Honorable Chair, this now brings us to another aspect of our investigation in this Office of the State Attorney. As we mentioned in our last appearance, that there's a phenomenon that the investigation is revealed of intermediaries. This intermediary is not appearing as middlemen or middlewomen, and they cost the state a whole lot of money. If you can see on that first slide that I'm reflecting now, at our last appearance, one intermediary, just really the period 2018, cost the state about 123 million for services reportedly rendered to the Office of the State Attorney. We are also pointing out later on that all of these intermediaries, we could not find that the department or the state attorney's office in particular has followed a procurement process. There is no written contract that we've seen between the department and these intermediaries, and they're really costing a whole lot of money. And in our view, it's an unnecessary phenomenon when the state attorney's office could work directly to these service providers, rather than having a middle service provider who is now just really our experience is that they really do little to deserve that kind of money. So in this regard, we have already notified the department. We've sent the letter containing all of this information to the Acting Director General of the Department of Justice on the 9th of March. Our expectation is that we expect the department to act on this so that they can mitigate the losses, the risk of losing to these intermediaries going forward. The next slide is still around the intermediaries. As we say there, with the evidence reveals that the department is excessively charged by these intermediaries. There's one that we mentioned there. The investigating team has discovered that one intermediary, the name is Genelite, for previous services were in the total of about 9 million, just one intermediary. So there's also considerations that we make and send to the department where there's a possibility of an immediate recovery in the form of set-off, or if then there's going to be a need, depending on the irregularities, that we will then engage with the department and institute a civil litigation process. The next slide deal with state attorney officials, others who were now involved in this anomaly of appointing intermediaries. As we say there, state attorney officials who were colluding with the intermediaries in defrauding the state. So on this one, we've got officials 1, 2, 3, and 4. There's amounts that are involved against each official. The investigation around them is complete. We are just still compiling the evidence pack to make the necessary referrals. We've indicated there that we anticipate that these referrals will be made in July. So this would include disciplinary processes, referral to NPA, and referral to special tribunal. So for recoveries. Our expectation is really that we would like to see, based on the evidence we've presented, consequence management following. Again, similar to what happened in the Eastern Cape, we started in Gauteng after the Office of the Premier approached us. We seconded SIU officials to go and conduct a similar investigation that we conducted in the Eastern Cape. This was, again, although this focuses on the medico-legal, but in the context of the Office of the State Attorney investigation, we also focused on the irregularities between the State Attorney's office and the officials. So the investigations really revealed an overwhelming evidence of fraud on the part of the attorneys and also on the part of some of the officials. As you can see there in the middle of the comments column, those are the nature of misrepresentations that the attorneys would be faced with. The plaintiffs really contradicting what the attorneys would have indicated. The plaintiffs really never, on the first case, the plaintiff confirming to the investigators that they never submitted a claim, contrary to what the attorney is saying. In the second one, the plaintiff not being unaware of the amount of money being claimed, and so on. So, Honorable Chair and Honorable Members, this, to our view, reveals quite a mammoth fraud being committed by these legal practitioners. So the status since we appeared is that we have now made some recommendations to the Office of the Premier in Gauteng so that the matters can be appropriately attended to. Then the criminal cases have been opened against the state or attorneys involved, and we're also looking at some of the officials who may be involved. Just to add, there's a comment on the top there, extreme right, that SIU is currently applying for a national proclamation to deal with the medico-legal irregularities. This investigation, the focus of it is on the Office of the State Attorney, the officials, and the attorneys involved, and other practitioners, whether it's health practitioners or medical practitioners. So the medico-legal claims, the focus, it's really different. So that's why there's merit in applying for a national proclamation, and that process is underway. So the explanation on the first case, it's similar to the second case, the third, and the fourth. But as you can see, that there's quite a number of attorneys who are involved. We've also requested the Office of the State Attorney, and this is in Gauteng, because of what we have observed, similar to what we have observed in Eastern Cape. We have said to the State Attorney they should really consider defending these matters or acting in a manner that takes the public interest into account. Because what we have noticed is that there has been some inaction on the part of the State Attorney's office. And the total amount of these cases that we have identified is just above 89 million rands. Right, we are almost at the end of this first part of the presentation, Honorable Chair. The next slides really have really not changed since our last appearance. We have also made some follow-ups in terms of where these cases are. These are the cases that were determined as part of our secondment team, but they've also now fed into this proclamation investigation. We've identified there's a number of attorneys involved. On this one, as we reported before, there's one attorney. In this slide that we are projecting now, Attorney Nonguba Incorporated, 1, 2, 3, 4, 5, 6 areas where the same attorney is involved, and you can see the amounts, just over 15 million. In fact, the same amounts for all the claims. So really, that's a risk indicator, and the team followed up, and I'm really happy that in this case, in this case, the attorney has been arrested, And this was a clear collaboration between ourselves, SIU, NPA, and the Hawks. So the attorney appeared in court and he was given bail. I can't recall the exact amount of bail, but it was quite significant. Following his release, he immediately followed up with the office of the sheriff in Gauteng for payment of some of the matters. And the sheriff, because they became aware of the work we were doing, they notified us that this attorney is demanding payment, and we asked the sheriff to stop the payment. We went to court so that those payments can be stopped appropriately. And so all these matters are now in court. We're expecting all those matters to be dealt with. Cases have been registered. These are criminal cases now, and they are receiving attention. On the extreme right, as we followed up, we were informed that all these matters are on the court roll, and they've been postponed to September 2020 in the Bisho High Court. The next ones are different attorneys, different to Nonguba, but in these ones, we are also going to make similar referrals. On this slide, we are showing that as a result of our investigation into the Office of the State Attorney, action has been taken against the head of the Office of the State Attorney in Johannesburg. And we are glad that the department acted swiftly from a disciplinary process perspective. We are informed that he's no longer the head, but the civil litigation process is underway. As you can see, we found out from the special tribunal that this matter is under case management by Judge Siwendu. So we're expecting that the court case or the court hearing date will be given at any time once the case management is done by the judge. As we indicated, Honorable Chair and Honorable members, that amongst others, as we investigate, we come across systemic inefficiencies, and we make recommendations to the state institution. There's quite a number of recommendations that we have made. These were sent to the Office of the Solicitor General. There's a need for vetting of employees that we have determined. The experience level of legal practitioners, enhanced and continued legal education, development and maintenance of proper briefing policy, proper filing system, creation of panel of service providers. We also determined legislative reforms that could be made, obviously subject to Solicitor General, the department, and the minister, and ultimately the honorable committee in terms of those legislative reforms to bring in improvements in the services and administration of the Office of the State Attorney. There's also an issue around the risk that the state runs on a continuous basis, which is the risk of prescription. So we have implored the Solicitor General to really look into that space, because it's costing the state a whole lot of money. And then there's a client relations issue there that we have pointed out. As I indicated, the investigation is underway. We anticipate that it should be done by the 30th of August 2020. Honorable Chair, this is really just a summary of all the referrals that we would have made. Up to now, there's 10 criminal cases, number of disciplinary referrals. As we speak now, I think we made a disciplinary referral relating to the head of the state attorney in Joburg. There should at least be one. Number of systemic recommendations, number of referrals to professional bodies, referrals for blacklisting, and matters pending in the civil courts, amounting to just over 136 million. The risk, I've asked the team to do a risk assessment of the investigation project. and these are the risks that the team have identified. They've also worked on the mitigation plans. We do not expect that these risks will materialize. However, we need to make sure that the mitigation strategy is monitored so that the risks do not materialize. There's actually no red flag that we need to raise at the moment. The investigation is ongoing, with the exception of the COVID impact, because it's impacting on availability of witnesses and the documentary flow, but we have put in place measures to ensure that we interact with the department. Honorable Chair, this excuse me, this brings me to the end of the State Attorney presentation. Now the next presentation is about the building of the courts. And as we start, Honorable Chair, our Chief National Investigating Officer has just walked into the room, Mr. Lekgeto. He's the one that's really overseeing all these presentations. He was busy with the exam. He just completed and is with us now, just to report. Now, on the apologies, Honorable Chair. I seem to have clicked a wrong button. The building of the courts, with again also focus areas. We've built the investigation in terms of focus areas 1 up to 6. The progress of the investigation, I think we haven't really changed since the last appearance. There's been some progress noted, which we will indicate now. When we last appeared, we indicated that the building of the courts, the budget was about 3 billion for the courts mentioned on the second bullet point, which is in Mpumalanga, Plettenberg Bay, Boysens, and the others, for the construction of 8 courts, which was 3 billion, including those courts that have been mentioned there. The budget was 3 billion, which was budgeted. But we indicated that evidence revealed that the budget was exceeded. So there has effectively been a budget overrun of about 100%, which is 6 billion. It's shown on the right-hand side. So the investigating team has now really confirmed that it is indeed 6 billion that has been exceeded. So this budget overrun really, as far as we are concerned and by any standard, is unacceptable. There's a clear indication of poor project management. There's a clear indication of poor project oversight. As we indicate there in one high court, the investigating team there did a site visit. There was poor workmanship that was evident, with the electrical appliances or electrification was also not up to standard. The team will still just check in terms of the certification of those who would have given assurance that all this was done properly. We would like to know who are those who provided the compliance certificates. So in this construction of courts, you'll see on the right-hand side, the first bullet point, the department used Independent Development Trust as an agent for the construction of these courts. But my engagement with the team is that we obviously need to investigate the extent to which the rules of principal and agency would apply. This does not exonerate the department. Even if the IDT was an agent, we would like to understand the extent to which the department was involved in the oversight and executed their responsibility as a principal versus the agent. So that part will happen. The lead investigator, who's sitting next to me, has informed me that they've engaged the acting Director General of the Department of Justice in terms of now inquiring at what level that the evidence point culpability. And we want to really itemize those, say who was involved at which level, who did not do what, just so that we can point out the responsible persons. Honorable Chair, these slides, again, we presented at our last appearance. You'll see there that in terms of the PFMA, there's some requirements when the project is to exceed the initial budget, and there are provisions in the PFMA and its regulations in terms of the extent to which the budget can be exceeded, and there are also requirements in terms of how it should be exceeded and who should authorize and what is the percentage. The team have determined that in this construction, PFMA states that the approved excess would not be more than 20%, but it should also be authorized. Up to date, we have not seen any authorization of that sort. As far as we are concerned, there is a fiduciary duty attendant to the officer, the accounting officer, in terms of ensuring that all of those are complied with. So as we were saying, we will now seek to point out the officials who were involved, either at IDT or at the department itself. And on the right-hand side, the third bullet point, there's a quantity surveyor who did the SCM process. The SCM process to appoint the quantity surveyor has been completed. We would like this quantity surveyor to work with the investigating team so that they verify all the losses that the state may have suffered in this investigation. Referrals to the tribunal and NPA and asset forfeiture unit, those will be made at an appropriate time once the evidence pack have been completed by the investigating team. Similar to the above project, we have identified the risks, but again, we are monitoring these risks to ensure that they don't materialize, so that they shouldn't derail the investigation. We have taken into account the disruptions occasioned by COVID, but we have put in place mitigation plans to recover. On the statistics, because of the costs that have not been billed, this is the investigating team's view that because they have not been constructed, we couldn't really say there has been any really losses. But that really doesn't end there. If the budget was spent appropriately, in all probability, we could have seen this courts also constructed. There hasn't been any referrals up to now, but the investigating team will move to make sure that we move speedily towards appropriate referrals once the evidence has been put together. Right. Honorable Chair and honorable members, I come now to the investigation in the Master's office. When we last appeared, this proclamation had just been proclaimed and signed off. It's also divided into focus areas, focus area 1 up to 4. As we sit today, the investigating team has received about 181 matters that are currently under investigation. So what happens is, since the proclamation was proclaimed, there is a whole number of allegations that are being reported, and they are being included into the investigation scope. Again, this slide really just indicates that the investigation is underway. There's an assessment of documentation that is going on, profiling of persons of interest. We also liaise with public protector, SAPS, and where appropriate, NPA on previously reported matters. Now, to date, having assessed the evidence that we have received, the investigating team will be making about 15 referrals, and we are in the process of finalizing those referrals. As we speak today, we have made one referral against the most senior official in the master's office, and that has been submitted to the acting DG. We obviously expect that action will follow. The number of criminal referrals identified is about 15, and those would be sent through once the evidence pack is completed. We found that this investigation, as complex as it is, we needed to augment on our capacity. Through the state attorney, we were able to appoint one expert who's the practicing attorney, knowledgeable in this area, is working with the team, and they've really been able to speed up some of the findings and the recommendations. The team has also engaged with the Justice College. We have engaged with them just so that they could provide training to our team to raise up the capability of our team. The preliminary observations, we've made various observations which we really take into account as we investigate, but just to make sure that the investigation is not sidetracked, because we do find that members there at the master's office, it looks like there's quite a number of acrimony. They open cases or grievances against each other. So what we have also found is that there's also allegations that are centered around the appointment process and alleged interference of officials from the master's office in favoring certain liquidators. There seems to be a mistrust, as we've said, of some of the employees there, but we just really mentioned these are some of the observation. We will deal with them as we investigate. We've also observed that there's a whole lot of non-automation in that office. So as a result of that, it really opens up the system and becomes vulnerable to abuse and possible irregularities and corruption. Right, we've made several recommendations up to now based on the observations we have made. There's reference to, and again, we're not going to go into detail about this. We've referred them to the acting DG of Justice, but there's also reference there that we've established that there's some regulations in terms of this Administration of Estates Act, which were supposed to have been promulgated, and this would really assist that office in terms of the appointment of executors in the deceased estates. We have brought it to the attention of the department and to the minister. I'm sure they will apply their minds onto that. The frequency of accounting by curator bonus. Remember, these are the practitioners appointed. Notably, they are the practicing attorneys as well. They are appointed to manage the affairs of those who really cannot manage their own affairs. But what we have found out is that there's also vulnerability in this case. There's the current requirement is that they only report annually. So we are of the view that if the reporting requirements can be changed such that there's frequent or regular accounting by these people, this would really limit or mitigate the irregularities, and also this will subject them to frequent auditing, if not real-time auditing. So that would mitigate the list. the risk of corruption. We also, from the staffing part, we found that in order to mitigate this risk, we have recommended a rotation system or a segregation of duty system where appropriate. We found also that there's a prolonged acting positions in that office, and that doesn't really augur well. We are saying the department should attend to that. We're saying the minister should re-examine the discretionary powers of the Master of the High Court to appoint previously disadvantaged liquidators, as the discretionary power is open to abuse. We are saying there should be a proper system, a proper process that guides the appointment in that area. The minister's policy on the appointment of insolvency practitioners should also be finalized. Stricter security and monitoring measures be implemented in the registry section. The investigating team also looked into that area. There's also a section another section in this Administration of Estates Act, which is Section 28. This section deals with the opening of accounts and the usage of check facilities. So we found that it's also a vulnerable area where the department should really review. Benchmarking against another state entities regarding the best practices of handling of checks. This is related to that Section 28. We are of the view that the handling of checks could be changed for other money handling processes, which would advantage the office of the master. We're saying also the verification of documents is an important part. That to be done at the inception of the transaction, to the master closing of a transaction, especially but not limited to the payment of the master's fees. So around this fees management, we have also identified some improvement. The regular monitoring of whistleblower hotline, we've also said that, and that's the again the summary on this slide projecting now the summary of the referrals. We've made disciplinary referrals, systemic recommendations. The investigation is still underway. As I indicated, on the criminal side, to date, we've identified about 15 that we will be making in due course. We've also done the project risk assessment to this investigation project. As you can see there, availability of witnesses is an issue due to the COVID-19, but we are also considering the use of technology solutions to the extent that it can assist in obtaining credible evidence, and then the availability of documents. We also put in place mitigation action. Honorable Chair and honorable members, at this stage, with your permission, Honorable Chair, our chief legal is the one who really made our Chair, chief legal. Sorry.
No, we have given you a lot of time.
Okay.
We still have 3 other matters that we need to deal with, and members have not engaged with you.
All right.
So we've given you an hour already.
All right. Chair, our chief legal will summarize this. This we have spoken to NPA, but we just really want to summarize where we are. We won't be long. And by the way, the
3 minutes advocating team.
Okay. The context of this is that when we implemented our new value chain as back as 2017, part of the value chain included the requirement to follow up on those recommendations that we have made to all the state institutions that we make referrals to, be it the state institutions, NPA, and also civil litigation. So we found that there's a need for improvement to improve the mechanism of facilitating our cooperation with NPA. Our chief legal will go through it quickly. As we said, we've also spoke to NPA about this.
Sorry, sorry, Advocate Mtebe.
Yes.
I think we will treat that as item number 2. That will also include the NPA.
That's right.
To deal with a briefing on the mechanism. So it's not part of the first presentation.
Yes. Okay. Oh,
So
indeed. Okay. Thank you.
We'll come
Okay.
back to it.
Okay. No, thanks. Thanks, Chair. So we can take questions relating to the first part of the presentation.
Thank you very much, Advocate Mtebe. I will now open this to members for questions, comments, and other inputs. I have 3 members that have indicated that they want to ask questions. It's Advocate Glenis Breitenbach, Honorable Maseko Zele, and Mr. Honorable Swart, in that order.
Myself, Chair, my hand is up.
Oh,
okay.
Honorable Mfukeng, and then I see Honorable Horn in that order.
Okay, thank you, Mr. Chair. Good morning, Mr. Mothibi.
Good morning, Honorable Breitenbach.
I hope you're well. Before I start on the material covered in your presentations, there are 1 or 2 other issues that I want to discuss with you, please. And if you don't have the information readily available, I'll be very happy to receive it in writing. There are a number of investigations related to the National Department of Rural Development and Land Reform that are outstanding. And some of them are really quite old. So I'm going to give you the numbers of the ones that I'd like a view on. 8 of 2011, 53 of 2012, 7 of 2014, 599 of 2015, 24 of 2017, and 32 of 2017. All of those remain active on your website. Even the ones that come from, there's 5 of 2007 and 18 of 2005. So those are all active on your website, and some of them are, I mean, you'll agree with me, very, very old. So if you don't have the information now, I'd like a written replies to the status of those investigations, please. Then with regards to the state attorney, what is the progress with the criminal charges against Mr. Lekabe? What is the current status of that issue? You mentioned that one of the advocates has approached you in order with an offer to pay. It's not my place to tell you how to do your job, but might I suggest that before you accept an offer to pay from anybody, that you discuss it with the NPA. Some of your offices were closed due to the COVID-19 pandemic. How has this affected service delivery, if at all, and what is your mitigation plan? Then there are loopholes with regards to the procurement process of the state attorney. What have you done in the interim to ensure that that these are taken care of and that no further abuse takes place while the investigation is ongoing? With regards to the new courts, at the last meeting you told us that you were appointing a quantity surveyor. Has this been done? And if so, has he finalized his work? Excuse me. With regards to Goodwood, Simonia and Tineng courts, you say there was no construction, so no loss. What happened to the funds that were allocated then to those projects? Last time, with regards to the Master's Office, in the last meeting, you explained that you had a critical shortage of forensic capacity. Has this shortage been addressed? Have you managed to appoint people? So is the forensic work on that investigation now proceeding? And in that vein, has any information been obtained from the vast quantity of computers that were seized from the Master's office. Then your memorandum of understanding with the National Prosecuting Authority. What is the status of that, and is it yielding positive results? That's all I have for the moment. I have other questions, but I'll see if they're covered by other members. If not, I'll ask for a second bite at the cherry. Thank you.
Honorable Jala.
Thank you, Chair. Good morning, Advocate Mutivi and the team. Chairperson, I have a few questions here that I would like to ask. But firstly, I would like to be reminded, Chair, I don't know, by Advocate Mutivi, that by the way, the issue of the names, why are we calling these advocates by A, B, and all that? I'll tell you why, Chairperson, I'm asking this question, because everybody who is involved in corruption has been named. And these ones, their names are not exposed. We don't know about them. We know that they are A's and B's. And these people are watching us right now as we are speaking, Chairperson. And they can see that we agree in hiding their names, because even the president and also the high officials, the politicians, their names are out there. Whilst there are, some of them are still in the system, why are these ones are exception? If I can be reminded, maybe I don't know where that decision was made, because I was not part of it. And if I was part of it, I think, Chairperson, from today, I'm out. The public wants to know, as it should be, this thing, it cannot be biased. Everybody, if you have done something wrong, your name must be outside there, so that people should know that we are investigating you, as it happens also with other people. We should treat people the same. And the second one, even the officials, what I've noted here, even the officials, here we are being told that their names also are not there. They are not being exposed. In fact, we are supposed to be doing oversight. So we need to know about these people ourselves. I'm sitting here, I don't know. So if I can be assisted, exactly where is that decision has been taken from? And if I was not part of it, can it be reversed? And then the second one is, my question is, Chairperson, how long does the SIU take in terms of time, the time frame, when it comes to these issues of referrals, so that we are able to monitor exactly that at least we have made this referral on this date, and then we are expecting results here on at least within this time, so that we are able to monitor this. Otherwise, we are just working without knowing when are we going to end this one, Chair, these issues. We want an end on this. And then also, we are being reported that that the membership of some of these advocates have been revoked from from the Bar Council. But I just want to find out, are they being suspended? Are they still working every day, some of them, in the offices? I would like to know, Chairperson. Another one, the question is that on page 66, number 6, the advocate is referring to the regional representatives meetings. Can we be briefed or be informed about the recommendation of these meetings? Because we want people to meet and come up with recommendation in assisting us as to how to go about and how to to deal with these issues. And then also on the slide number 7, that one is number 6. Number 7, there is an abbreviation there, which is HOU. I don't know what does that mean. Because you are saying you are expected to report there quarterly. What is that HOU? The meaning of that word, HOU, the application. And there was also in your slide where you referred to the letter of engagement with the Justice Department. I also would like to get a report on this one. There's a lot of money that we have lost here on this, as you said, on these intermediaries, a lot of money. This report is really stressing one. When I was reading it, I got so stressed. Stressed up, I even wanted to find out exactly from the advocate, are we winning? Are we really winning, or are we just rounding in this cycle without getting a breakthrough? Because when I check at the results of what we are doing here, they are really minimal. Can we get an answer? Are we really winning in fighting this corruption? On the Master's Office chairperson, that one, it's bad. There's one that they are referring to, the Master's Office in Pretoria. You know, there was a time when the community of Pretoria North were complaining that there are so many properties that belongs to government in that area that has been captured even by the outsiders, the foreigners. Now they are charging them monies. So if the Master's Office is so bad, corruption is up to the neck, how are we going to win that one? Because we don't even know what is the government owning, chairperson, when it comes to these properties. There are so many properties outside there that we are supposed to be having as government, but we don't know about them. Can we speed up and in fighting corruption in that office? These people must be arrested and they must be charged and go to jail. Chairperson. And then also on the building of courts. I just want to know from the advocate, because you are saying here, you still have to find out exactly who offered the compliance certificate when it comes to these buildings, a building of courts. And if I'm not mistaken, this is the statement that I heard, even I heard about it last time. How long does it take the SIU to get only the compliance certificate to get that information? Chairperson. And then lastly, Chairperson, the protection of these whistleblowers. Well, how safe are they? Because if there are some delays in getting or arresting these officials, the very same legal officials, Chairperson, that we are relying on them. The issue of the whistleblowers, how safe are they? Are they still giving information in connection with these things, if maybe these cases are not resolved?
So Honorable Chair, there is some board who's disturbing us. IT, can you deal with that? Thank you very much, Honorable Chair. Honorable Swart.
No, thank you, Chair. And I just want to thank Advocate Matiba. I want to thank the NPA, the SIU, for the incredible work that you are doing under very, very difficult circumstances. And I want to encourage you, never give up the fight. Continue, continue, continue. In this regard, I did raise the issue of capacity and the issue of speedy proclamations with President Ramaphosa during question time, and he gave an undertaking to ensure that proclamations to the SIU were speedily finalized. And I'd like feedback in that regard as to whether, Advocate Matiba, there has been an expediting process in finalizing your proclamations from the presidency side, because he did give that undertaking. Secondly, on the issue of capacity, clearly at your last meeting, you indicated to us that there is a capacity problem given the 78% increase in proclamations in the last quarter. And I'd like to ask you how we as a committee can further assist you, given the increased workload that you've got. But I just want to say I'm incredibly impressed by the presentation and the progress that you are making with the NPA, with other law enforcement agencies under very, very difficult circumstances. That having been said, I must say it is deeply, deeply sad that here in the Justice Department, we have these high levels of corruption. You would have thought that at least the Justice Department would set the standard. And these allegations of the state attorneys and other advocates are absolutely disgraceful, given that these are officers of the court that are supposed to set the example. Now, with the state attorney's office, I'm very pleased with the progress, but the key aspect to me is, besides the criminal investigations, is the recovery of the funds that are being stolen. And yes, you are cooperating with other law enforcement, with the NPA, with the asset forfeiture unit, with the special tribunal, and you were able to get a preservation order against Mr. Lekaba for the 4 million pension. Can I ask you, I do see you also referring to cooperation with SARS. When you do lifestyle audits, you can get an immediate cooperation with SARS that they can attach every bank account of a person where they can prove that there is a capital reconciliation and that there are funds. So where a lot of these funds have been taken, important that there is this joint cooperation and speedy action. Because when we find, in my experience, we come 2 years down the track, 3 years down the track, and their money is all gone. So it is key for that speedy cooperation. So if you could give us an indication of progress in that regard in this narrow ambit, but maybe the NPA as well later, given the additional funds that have been given for COVID-19 and the cooperation to protect those funds. That's a broader issue. But we need to understand that we are sitting with a looming sovereign debt crisis. The fiscal space, as we all know, is critical. We are looking, and so we've got to protect every cent. That which has been stolen must be recovered. That which we're presently spending must be properly spent. I'd like to also ask you this issue about the state attorney. This thing of brokers and mediators, intermediaries, I cannot understand what it is, what the purpose is of that. And to me, that is a lot of excessive and unnecessary expenditure. And I'm appreciative that it's been stopped in certain offices, but it must be stopped immediately. And Chair, in general, we need to start looking at state litigation in general. We need to exercise our oversight far more accurately, because these are issues over the years, we have the state attorney, the department comes and they present, they say the master's office, everything is fine. But now we see it is rampant corruption, as Advocate Matiba said. How did we miss our oversight? And I think we need to improve that as well. When people bring us information, that we don't necessarily just accept that. When it comes to Advocate Matiba, you said you're looking into medical legal claims, you're looking into police claims. Of course, we know there are billions of rands of contingent liabilities there. So, Chair, we need to, both from our perspective, exercise oversight with state litigation and, of course, look into these particular issues. Now, when you get to the Master's Office, I fully support the recommendation of some time of frequency auditing. I would like, and I've said in the Finance Committee, that the COVID-19 additional expenditure should have real-time auditing with the Auditor General's office. These are issues that we need to look at to protect and be good stewards of our finances that are being spent at this time. So, Chair, just from my perspective, I would like to see more speedy action when it comes to the disciplinary action of these officers of the court that are supposed to protect state resources, and we appreciate the multiplicity of work that is being done. But I would then like to just ask a few more general issues, and I'd like to ask, so our budget at the beginning of this year, there was an additional funding over the medium term of 225 million for the SIU. Is that sufficient? And we now see we've got the special budget where there could be an adjustment or up or down of the SIU's funding. Clearly, I would oppose any of us, we would oppose any reduction of your funding as we would for the NPA, which was given an extra 1.2 billion in February. And I would like you to just comment on the impact of capacity, given the enormous amount of work that we expect you to do, but it is critical. As I've said, and the Minister of Finance said that he has heard the ACDP, the necessity of the asset forfeiture unit, NPA, SIU getting additional funds because you can collect billions of rand. So, Chair, we need to focus on that as well. Thank you. I might ask further questions in the second round. But lastly, Chair, just the special tribunal, the matters that have been enrolled, maybe you could give us an indication of the progress of those matters. On the 16th of May, you indicated 20 matters had been enrolled, 21 billion rand possible recovery, and there were another 15 to be enrolled. We appreciate that COVID-19 might have an impact, but maybe you could give us an update of the matters before the special tribunal. Thank you, Chair.
Honourable members, I don't think that there's going to be a second round. We still have to deal with two other issues, including the Human Rights Commission and the Information Regulator, and we still have to deal with the issue of the NPA and the SIU. So I don't think that, and the House starts at 2. So I don't think that there's going to be a second round. People must ask their questions now if they want to ask questions. Honourable Horn.
Yeah, thank you, Chair. And for the sake of time, I'll try to be brief. I firstly want to latch onto the issue of the intermediaries already addressed by the Honourable Maseko Jele and the Honourable Swart by saying, or really asking, in addition to the possibility of looking into recovering some of the monies paid to the intermediary, if I recall correctly, the presentation said there was even in the Eastern Cape somebody who claimed nearly 10 million rand for work previously done. I mean, this clearly is a case not only of fraud, but of grand scale corruption. And we're back at that point, Chair, where we must ask, I mean, if the interim report to the President is only due in August, and we're appreciative of that, and we will be getting to the relationship between the SIU and other entities like the NPA and the Hawks, but clearly the issue of intermediaries calls for immediate criminal action. If not in terms of the common law, then at least in terms of the Prevention of Corrupt Activities Act. So I would like to know what, if anything, have the SIU done when they discovered this practice of intermediaries to also immediately see to the fact that there should be criminal action. Then on the issue of, Chair, the court buildings, and the Honourable Swart has referred to oversight. I mean, it is so that those of us who had the benefit, I don't know whether it is a benefit these days, to have served on this committee during the 5th Parliament would recall that we have had meetings specifically with the view of playing an oversight role over the department in respect of their build program. And ultimately, we were informed that, yes, while there were challenges, all the time they were confident that things ultimately would be sorted out. Only for this whole issue to be now the subject of an SIU referral, and now we learn that in stark contrast to the presentations which indicated that the overruns in terms of the costs would be minimal, that there's actually been a doubling of the costs. And the presentation talked about poor project management and also ultimately the fiduciary duty of the accounting officer. And I want to make the point that as we speak, the previous Director General has now been, I don't want to say rewarded, Chair, and I don't want to make politics of this regarding cadre deployment, but he's now been appointed as an ambassador. And I want to ask Mr. Mutibi, to what extent have they looked into reporting immediately to the President once it is discovered that quite possibly the accounting officer didn't fulfill his role and duties in respect of these projects of the department in the manner the PFMA demands of him, to report that at least to the President, so that we don't sit with the situation where an acting DG must now answer to questions and the DG has been rewarded with a position as an ambassador. And then lastly, Chair, in respect once again of the State Attorney's report, I want to understand properly the issue of rescission of judgments. Because if I understood the presentation correctly, it has gone as far now as that the SIU from their side step into the shoes of what should really be the State Attorney to see to it that certain judgments which were given against the state on the basis of negligence on the part of the State Attorneys are being rescinded. And if that is indeed the case, then I think it is highly problematic in the sense that we've been assured from the Minister's side that the necessary steps have been taken to restore the proper functionality of State Attorneys' offices. Whether it is in fact proper for the SIU to step into the shoes of the state and rescind judgments which should not have been given, that's a whole other issue. But I want to understand that whole matter regarding rescission of judgments given against the state better. So if we could be appraised as to who plays what role in that regard, it would be appreciated. Thank you.
Thank you, Honorable Mufokeng.
Thank you, Chairperson, and thanks for the presentation, Advocate Mutibi and your team. I must say that it's true that you have improved a lot from the last presentation. There's meat in your whatever document. I want to start on the issue of the State Attorney. I want to check on the time frames that you are having. What is it that is going to happen now that you have COVID-19? And I noted that you had time frames from June, July, and August. And I'm asking myself, that is it still going to be realized? Maybe you can help us on that. And on the matters of SAPS, I realized that in Free State you had about 2,571 cases, but you managed to identify 227. And the question is why? Because with other provinces, you managed to actually be on 70 to 80%. Do you have a problem of capacity here? And then will the unit actually be able to submit the interim presidential report, as your set date is the 30th of August? And then being realistic about the processes, you need to be telling us whether you manage or not, because your final report will be expected in February 2021. And now on the recommendations you made in terms of the Office of the Premier in Gauteng, how does the unit monitor that your recommendations are actioned? Because we are tired of getting information of so-and-so is investigated, but the next thing is quiet. Nobody knows what is happening. And I'm thinking that equally so, when you do an investigation, you need to also come out to say, we are done with the investigation. It has been handed over to where it belongs, because it makes as if, people are not effective. So it means that with Ntate Sipho being there now, you have to up your game, and the team that is there with the NPA, all of you, to make sure that whatever comes out in the media, you later come out to say, we have done so and so. It's for those who have to receive and do the rest. On the issue of Advocate Lekabe, I'm covered by Honorable Breitenbach. I was going to ask the same to say that, is he criminally prosecuted? And I think that will assist us. The issue of the Master's Office, one is happy that you are handling this now. It has been for many years that people suffered under this office. It's not a secret that at some stage this office was closed, documents missing and all that. But what I'm worried about, the unit is investigating from the period of January 2014 to 2020. Then what happens to those cases that will come as cold cases? Will you be able to handle them? Because remember, citizens and people suffered, families suffered in this because of the meddling of files and whoever, the cabals that were taking actually whatever they do with others. But I must say that this office needs attention. Lastly, I want to check on the issue of the additional skills in terms of dealing with this office. You just mentioned that you have one expert. Is it enough to actually have one expert? I think this nature of the office of the master, you will be needing much to be actually done in this office. And on the issue of the template you have showed in slide 60, one is impressed about that. And I was asking myself that now I'm asking the question of cold cases. What will you do if you receive them? Will you have a template that shows all of that? Noting that some of the issues that have been raised by Honorable Breitenbach to say that we still have cases that are investigated from 2005. We should be knowing the timeframes of investigations on dealing with matters like this. And I want to agree with Honorable Swart that the frequency of auditing in the Master's Office is imperative. Thank you very much.
Thank you, Advocate Mutibe.
Honorable Chair and honorable members for the questions. Honorable Breitenbach, if we can undertake that we will send a written report on where all those investigations that you have identified are. So I need to just indicate that as part of our new strategy is, and it really shouldn't have waited for the new strategy. We are seeking to expedite our investigations and the related outcomes, and in following up with all the matters that have been referred to. So if these cases have not been finalized, it would really be a worry, because we have looked at all the cases in our books. We have managed to ramp up all of those who were in our books for more than 5 to 6 years when we first started with our strategy, and we have managed to make sure that they are completed. We will also ensure that the website reflects the status as we will report. So we will report that. In terms of the timelines, because it should really be quite quick for us to pick up the information, we can, if it's acceptable, Honorable Chair and Honorable Breitenbach, we can submit that within 7 days from today.
It would be fine for me. Thank you very much.
Thank you. 7 days. The issue of Mr. Lekabe and his criminal charges, I'm informed now that the criminal investigation is ongoing. So he has not been charged yet. So the Chief National Investigator, Mr. Lekgetho, is sitting next to me here. He says the criminal investigation is definitely ongoing. So we can confirm that whenever he gets charged or whenever it progresses, we will then update the committee accordingly. On the advocate that has offered to pay, and thanks for pointing that out. We will not actually accept the offer to pay, and indeed we will engage with the NPA, in particular the asset forfeiture unit, to ensure that where the state has suffered as it did now, there are considerations to then kickstart the asset forfeiture unit process. Obviously, the NPA will advise in that regard. Some of our offices closed during COVID. When the lockdown started in level 5, the SIU was not mentioned as part of the essential services. And we then engaged with the drafters of the regulations, in particular the Department of Justice. And then when the regulations were, the levels were lowered, level 4 and level 3 now, SIU has now specifically been mentioned as a permitted service. So we are glad that has happened. But still, even within level 5, when we were not mentioned, because we really viewed our investigation work as essential, and our employees really showed that level of appreciation. During that time, we received a few allegations relating to COVID-19. In particular, the assistance we gave to the Department of Public Works in investigating the Beit Bridge fence. We also investigated a matter in Gauteng relating to the IT procurement. And as Honorable Mufokeng indicated, we have now submitted our report to the Office of the Premier, and we have been engaging with the DG of the province to ensure that appropriate communication is done. And our head of communication, Mr. Khanyago, has been in engagement with the head of communications in Gauteng, and we have been informed that the Premier will communicate. We are continuing to follow up on that. Loopholes in the procurement in the state office, state attorney's office. We made this finding in the early days when we started the investigation, and I recall that there was even a session that we held with the minister at the time and the deputy minister, the Deputy Minister Jeffrey, and at the time it was Minister Masuta. We engaged with the officials of state attorney, and it was clear that there are no procurement processes in place to procure the legal services, and they undertook, and I'm informed that they have since implemented some procurement process, which now they invoke when they have to appoint legal practitioners. I know that they go on a quotation process, but we have been informed that they have since remedied that process. We'll probably just re-engage with them just to assure ourselves. But we've been assured that that part has been appointed. The appointment of the quantity surveyor, that has been done. In the presentation, I can recall the page number, we reported that was done on the 11th of June, and the work of the quantity surveyor will now kick off to ensure that we do the necessary quantifications. Relating to the forensic capacity in the unit, in SIU, indeed there is capacity that we have identified that if we don't attend to the capacity issue, we are likely to see the investigations being delayed and prejudiced at the end. We have now kickstarted the process to appoint, and this is also related to what Honorable Swart has indicated around the additional funds that we have been allocated. Those will be utilized to appoint forensic capacity. Just this past week, I've been engaging with our HR team. They are busy finalizing the advert, which we should see publicly in the next few days. So we are really working hard to make sure that we improve capacity in that space. But what we have since done as well, and this was done a few years back, that we have appointed a panel of service providers through the SCM process with those experts that we don't ordinarily employ. Like, for example, this quantity surveyor would have been employed through that process. The engineers, we've got also other specialist capacity on our panel of service providers. But what we have realized, indeed, is that their charges are really not as cheap. So the costly nature of their services just indicates that we should, where appropriate, appoint those services internally. But those purely expert ones, like engineers and so on, will probably still keep on a panel, because to appoint an engineer on a full-time basis, they will not probably be kept busy for the better part of their appointment. Information from the computers, we must really say that that has really proved overwhelmingly useful. The referral that we have made now onto this senior official that we are referring to, amongst others, is the information that we have scanned from various of the computers, including the interviews of the witnesses. So we do have the capacity internally to image and also to analyze. But what the investigating team have taken as an approach is that the investigating team would then scope an area which requires the analysis of certain computers, and then they will then stagger it in that form, so that the assessment of the imaged computers is led by the focus of the investigators. So we have seen that is quite helpful, and it focuses the investigation appropriately, and the analysis of the computers is focused so that they know what to look for. So the investigators inform the analytics, and they are able to then analyze as expected. Honorable Jelle, the issue around the names of the people who are involved. We do agree with you that we really need to make sure that the committee, the honorable committee members, and the public are aware of who is involved in the corruption processes, and just so that they know that we are holding them accountable. But the principle that we use is that at any point when the evidence is conclusive, and if I use the example of the civil litigation that we have end-to-end control on, once the matter appears in court and it's now recorded and then it becomes public, then we are able to then name the official without any legal risk that we could face. The same would go, I assume, in the criminal side, that once the suspect is arrested, once they appear in court, we are able now to communicate publicly to the public. In terms of the disciplinary process, the same principle would apply, so that once the official is charged, and more often they get suspended, more often the names get mentioned. So it's really just a principle that says we really safeguard the legal risk, such that we don't prematurely mention the names before the evidence is conclusive and the matter is now enrolled in court. But we do totally agree that those who are involved in corruption, they should be mentioned without a doubt. How long does SIU take with the referrals? The referrals are made as soon as the evidence point, for example, to criminality. We refer it immediately to NPA. And as I said, we then compile an evidence pack, which goes together with the referral. All these referrals, Honorable Chair and Honorable Members, they do not wait for the report to be sent to the President. The report, when it's sent to the President, it ultimately itemizes all those matters where action has been taken and they've been referred. So what we are doing at the moment is that we have a unit in our in SIU that focuses in the main on making sure that the referrals are acted upon. So we have ensured that we've got the focused function that follows up on these matters. I made an example earlier on that this was part of our new value chain, because in the past, SIU would refer and we would not follow up. So as logic as it sounds, it wasn't really done effectively before, but we are doing it actively now. And that is why we are able to comment and say at what point it's some referrals. So we will continue to do that. And as and when we appear, we will mention the status of those referrals in conjunction with the state institutions where we have referred to. The membership of the advocates, in where we've made referrals to the bar councils or the practice legal council, we do based on the evidence we've submitted, and we've seen that in one instance, at least the advocate's membership has been suspended. So we expect the same, that it should apply to all the advocates that we refer, all the attorneys that we refer to the Legal Practice Council. So ours is to really make sure that we follow up so that that impact is made. Loss of money on the intermediaries, we do agree, and we've pointed that out to the department, that as far as we are concerned, this is an anomaly or a phenomenon that is unnecessary. It has cost the state a whole lot of money, and we will, as we said, we've now communicated with the acting DG. We will follow up to ensure that there's change. This practice is stopped because it, as far as we are concerned, is unnecessary. Are we winning on the fight against corruption? I think this is a wider question that applies to all of us, and I'm sure my colleague Advocate Batoyi would also comment. We have in the past seen that there had been a general measure of inaction on the part of the law enforcement agencies, and that inaction, we are working hard to make sure that the interest, the public interest, is restored. And part of what we do in all of our strategies, be it Hawks, be it NPA, be it SIU, and this I can say with certainty because we do meet under ACTT, we are all geared up to make sure that we produce the results and the impact that's required. So from where we sit, my view, and it's shared widely, is that where impunity is seen to be condoned, then it fuels the continuity of corruption and certain criminal acts. So if we are seen not to be condoning impunity and we take action, hold those who are responsible to account, whether it's criminal, civil, or disciplinary, we will then send a clear message that we are acting and punishing those who are responsible. So in that way, we will be able to really see a progress in terms of fighting corruption and probably winning the fight. As far as we have done in our new strategy and the way we are doing things now is that we are ensuring that the impact of our work is felt and we continue to follow up. The masters in Pretoria, in terms of the properties that Honorable Jele has referred to, we will follow up on that aspect. I know there's a Pretoria leg and there's a Mpumalanga leg. There's various legs of this investigation. We will ensure that we follow up on those properties that Honorable Jele has referred to. The issue around compliance certificates, the investigation, as we said, has revealed poor workmanship and a whole lot of issues that have been identified. And this is on the part of IDT as an agent, but as we said, it doesn't absolve the department. So we have requested various information from IDT and from the department. So we will ensure that we speed that up. This request for information were disturbed. I was informed that there was a contract with Metrofile, which was problematic between IDT and Metrofile, and that really has caused the recovery of some documents to be delayed. But I'm informed now that it's been resolved and that those requests are being acted upon. Thank you, Honorable Swart. We would like to ensure that we continue to do our best to assist this honorable committee in its oversight and to assist government in the fight against corruption. We really appreciate the support in that regard. The issue around proclamation process. When around 2016, 2017, the same that we did with NPA at the time, we had identified that the proclamation process takes long, and there were no timelines on the part of DOJ, Department of Justice, and there were no timelines on the part of the Office of the President. So we entered into a memorandum of understanding, a tripartite MOU between SIU, Department of Justice, and the Presidency. And there are timelines that have been set out. And we were really happy that for the first time, we will be able to hold anyone accountable who does not stick to those timelines. We initiated that, and it was well received. We are happy that we monitor that. But there has since also been, a review. We've sat with the acting DG about 2 weeks ago, where we were talking about just this process again and reviewing whether we can further improve. And we are really delighted that there has been an improvement. And when it reaches the minister's desk, he looks at it and he dispatches it to the president. And we have seen that it really complies with the timelines that we have set up in the memorandum of understanding. The capacity of SIU to investigate, I think I did indicate that. In terms of the budgeting, our CFO sits in the room, is just indicated that we've been approached by Treasury in terms of the cuts. I think they've approached every state institution. At the moment, our budget will indicate I've got an indication that it will be cut by 10 million for this year. And there's probably other cuts that will happen going forward. So it's we are really, well, we could do with no cuts, but at least the cut is not as detrimental. So we will still be able to move with our recruitment process and make sure that we recruit the capacity into the into the unit, because indeed we have seen an upsurge in the proclamation process. The issue around DOJ with the Honorable Swart around the building of courts and so on, we have indeed engaged with the acting DG, and we will point out all of those who are responsible with the intention that action be taken. When in the initial presentation, the first slide, I did indicate that we interact with various regulators, including SARS. When we do lifestyle audits, yes, we do interact with SARS, and I can announce that we do have also an MOU, and we interact quite frequently with the SA Revenue Service. They've allocated dedicated resources to assist us, and we are seeing a good improvement in that space. And we also interact with the asset forfeiture unit, where evidence appropriately indicates that, and we have seen a measure of improvement in that regard. The issue around intermediaries, I think I've covered that. We are quite steadfast on that. That is not necessary. The issue around oversight of the committee, we are available to support the committee and contribute in our various investigations to just point out any of the findings that we have made, so that we can indicate to the committee, probably assisting where to focus. We agree in terms of frequent audits of the masters. More speedily action take in terms of, we would like to support that a speedy action has to be taken against the officers of the law, or officers of the court, or officers of the state. We have made that. Honorable Horn agreed in terms of intermediaries. Interim report due in August. We will ensure that we meet that date, because it's an interim report, is to indicate where we are, the status of the investigation. We have generally pulled back the timelines of the investigations. Again, when we adopted the new strategy, we have agreed that where an investigation is likely to exceed 1 year, because of the complexity of the investigations, we should issue an interim report. In fact, we are likely to review that 1 year, depending on the observations we have made. So we do issue interim reports once the investigations are likely to exceed a year, and we ensure that we speed up the investigation such that when the final report is done as speedily as possible. And as I said, we ensure that we don't compromise the investigation. Criminal action against intermediaries. Yes, we will ensure that the evidence, when it is available, we'll make sure that the intermediaries are pursued criminally as well. In terms of the rescission of judgments, Honorable Horn, we agree. I agree with you that it should really not be the case that we step up in the shoes of the state attorney, but in this instance, we have observed that there has been a measure of inaction, and that inaction on the part of the state attorney can be unpacked in terms of irregularities, whether there's been corrupt activities. So the state attorney is really not as passionate to take over these matters. So we've realized that if we do not act as we did, the public interest is likely to be prejudiced, and we are happy that when we engaged with the Solicitor General, there's measures now in place to ensure that all those matters are improved upon, so that we can rely on the Office of the State Attorney going forward. Around the Honorable Mofokeng, the time frames of July, August, as I indicated, the interim report, we will ensure that it's issued so that it clearly indicates the status of the investigation. Around the SAPS matters that we have received, there's various numbers that we have received. We receive cases, and as we sift through the allegations and the cases, the team end up with a certain number of cases. So the issue around capacity, there is always, and we have identified that we really need to improve, and we are going to speed up the recruitment process. How do we monitor the referrals to, for example, Gauteng? When we did a secondment or any of the referrals, we are following up with the office of the DG and the office of the Premier to ensure that when there's a need, and correctly, as Honorable Mufokeng indicates, when the public knows that we have been investigating a certain aspect and we complete our investigation, we need to ensure that there's appropriate communication so that we know that our part is ended and the report has been submitted, and the office of the Premier will probably do what's expected. We did say that Mr. Lekabe is also being pursued criminally. In terms of cold cases, those that date back, our process is to ensure that we bring them out, we bring them back to make sure that they are also attended to. I think I did touch on the timelines of the investigations. Honorable Chair, I'll pause here. I think I've covered substantively the questions that were raised.
No, thank you very much.
Oh, the issue around special tribunal. Sorry, Chair. There's 24 cases now issued at the special tribunal, and the value is about not 21, it's about 2.1 billion. Those cases that are in the ordinary courts, the value of the matters, there's about 14.7 billion. So we are trying to make sure with the judges' precedents to make sure that these matters receive attention, and on our part with the legal team, we ensure that whatever areas that the judges need support on in terms of case management, we are there to make sure that we do our part. Thank you.
No, thank you very much, Advocate Mtiba, and to your team. We are thankful for the work done, and we hope that with stage 3 or level 3, you'll be able to speed up most of this work, and we do appreciate that level 5 did have an impact on the speed with which we wanted to proceed in finalizing these matters. But we are pleased with the progress that has been made. Corruption by officers of the court, as we fighting crime and corruption, we expect officers of the court to be on the side of the people and not work against the people. So as this family, justice family, we must do whatever it takes to ensure that we bring those people to book. So what we will do, we will continue to have this matter. From time to time, we get this report. We will communicate when we will ask for a further report, because we don't want to have this matter below our radar. We want to keep this matter on our radar continuously. We are pleased that the NPA is also with us, so that the mechanisms that are going to be put in place, firstly, they must focus on dealing with this issue. Because can you imagine a situation where you would find that an attorney or an advocate one day becomes a judge or becomes a magistrate when he or she has been involved at some point in crimes against the state? So we take this as a process of cleaning up the justice system and of cleaning up our society, because we that must be on the side of the people, that is the officers of the court, and not with us. So we really welcome the work that has been done, and we are very hopeful that we are going to add more speed and more oomph, since level 3 allows you to do that, to ensure that these cases are really finalized. As Honorable Jelle said, we would want to see most of these people on orange overalls and money owed to the state paid. We can't accept that there can be 100% cost overruns on courts. It can't be acceptable. So no, we are really happy with the work that you have done. I think let's move quickly to the second item that I think is going to be presented jointly by yourselves and the NPA.
Thank you, Chair. As I indicated on our site, our Chief Legal will do a speedy presentation, which we have shared with NPA. I think we are on one page in terms of the mechanism. I'll allow him to present quickly. Dr. Wells will take over the presentation. Thank you, Honorable Chair.
Morning, Honorable Chair, honorable members, and colleagues.
Before you proceed, Doctor, I hope you wrote well, and I hope you passed. And I think that is what all members of the committee and South Africans would expect. We will wish you well in your exams, and in whatever you are doing, that you succeed. Thank you.
Thank you, Chair.
Thank you, Chair. Thank you.
Chair, the presentation that I will deal with includes slides 63 to 68. And I will move immediately to slide 63. The first bullet sets out the functions of the SIU, which is contained in section 4(1)(a) to G. Now, Chair, the interaction with the NPA is governed by section 4(1)(d) of the SIU Act, which basically states that if we come across evidence that points to the commission of an offense, that must be referred to the NPA or a national prosecuting authority. The evidence that we refer to the NPA is usually the evidence that we gather through our investigations based on the proclamations issued by the President. I will refer to page 64. SIU, based on the obligations of the Act, engaged in 2017 and concluded a MOU with the NPA. And this was basically just to give effect to the previous legislation or the section that I referred to, that is section 4(1)(d), also commonly known as the referrals that must be made to the NPA. Now, Chair, the last bullet refers to the nature of the evidence, which we refer to the NPA, and that is basically the allegations or evidence that points to maladministration, fraud, theft, and corruption. Concerning slide 65 and onwards, Chair, including 67, sets out the process that we engage or we have adopted in terms of the referrals. And in short, it deals that without going into much detail, Chair, it basically that the SIU refers a letter to the National Director, the head of the unit, refers a letter to the National Director in terms of 4(1)(d). Under cover of that letter, is an evidence pack, basically incorporating all the relevant evidence or the points to the commission of an offence. That letter and the evidence pack is served on the National Director personally. National Director of Public Prosecution, as well as confirmation of the responsible accountable official dealing with these matters on behalf of the NPA. That can be anybody from the SECU or officials from the AFU. Chair, there's regularly meetings held between the NPA concerning the planning of these investigations, as well as the involvement of the SIU investigations itself. Point 7, Chair, on page 67 is where the accounting authorities or the National Director of the National Director of Public Prosecutions then account to the HAU on a quarterly basis. The HAU is the head of the SIU, account to them quarterly on the status of each of these referrals made under Section 41D. Now, it is correct in summary, Chair, that this relationship and cooperation has been implemented, the MOU, Chair, but in terms of results, the parties have agreed that this has not been as effective as it should be. I'm now on page on slide 68, the first bullet, Chair. Now, in terms of the legislation of the SIU, namely Section 4.2, and this has been alluded to previously by Advocate Mutibi, the SIU has a responsibility to ensure that matters or evidence referred to the NPA are dealt with best and with intention to serve, or the purpose to serve, the interests of the public. And in this regard, both parties, the NPA and the SIU, has concluded and arrived at the decision that an integral party to give effect and to the referrals or the evidence packs sent by the SIU is the engagement and co-opting of SAPS as an integral party to the MOU. In light thereof, the parties have agreed that in principle that there will be a tripartite MOU to give effect to these referrals and deal with them. And of course, in the MOU will be set out the obligations of the parties, more specifically each party's role and accountability in the referral, investigation, and prosecutions of referrals made by the SIU. This process, I'm glad to report, will be finalized by August 2020. Thank you, Chair and honorable members.
Thank you. Dr. Paturi.
Thank you, Chair. I'm just waiting for my colleague to put on the presentation of the NPA. Chair, I will do just a very short introduction of the presentation, and Advocate de Kock will deal with the details. It's not a very long presentation. It deals with the coordination and collaboration mechanisms, so it will also be quite a quick presentation. Next slide, please. The presentation was sent to, can we make that a little bigger, please? Unfortunately, my glasses are not very good, and this is a really small font. Thank you very much. So, Chair, I agree with my colleague Advocate Mutibi that you know, in recent times the collaboration between the SIU and the NPA was for various reasons not satisfactory. And I recall that when I took office a year ago, well, it's 18 months now, 17 months ago, the 600 and some odd that, you know, were not being attended to. And so, you know, it was, the relationship was not at its best for various reasons. And so in the past year, a lot of time and effort has gone into building these relationships and ensuring that we work as a cohesive entity, recognizing that each one of us cannot individually on our own address this huge challenge that we have in our country. And so there has been a lot of ongoing engagements and collaborations with the SIU and other entities in law enforcement. We realized there were huge backlogs with a number of the referrals by the SIU in terms of the investigations. And we've been relooking the referral process, and Advocate de Kock will talk a little through that. But what we found is that, well, firstly, I should explain to you, Honorable Chair and honorable members, that it's important to understand that the SIU, in terms of their act, as Advocate Mothibi explained, refers the matters to the NPA. But the NPA is not an investigative entity. And so the directorate, investigating directorate, which is dealing with some of the matters that are in old SIU referrals, generally the NPA does not investigate these matters. And that is why, as Mr. Wells mentioned, we realize that it's important to bring the SAPS, in particular the DPCI, into this arrangement, because the process would be, the matters would be referred to the NPA. We would then send it on to the DPCI for investigations, and that's where things got a little bit stuck. And so with this tripartite agreement, we're hoping that things will certainly improve in that regard. And from the anti-corruption task team, where we work very closely together with a whole range of other law enforcement entities, we are also at the mother body of the JCPS cluster, looking at how we could actually enhance our coordination and collaboration there. And of course, this particular collaboration fits into a many more broad efforts to increase collaboration between law enforcement. Just in terms of one of the questions that Honorable Jelle mentioned, are we winning this battle? At this point, I can say we're not winning. I think we have to be candid about this. We are not winning this battle yet. As you saw from Advocate Mothibi, and this is just corruption in the justice, one part of government, and we're looking at private sector corruption as well. But if we just deal with SIU matters, this is one part of it. The amount of work that needs to be done is astronomical, to say the least. But it doesn't mean that we are not, we have to continue fighting, and we have to continue doing everything that we possibly can to make sure we address this. But I'm very pleased that I think it was Honorable Swart who mentioned the issue of the budget. We did receive a budget allocation last year, and in the AENE process, as well as in the MTEF process, and that we're very grateful for. But it's important to note that this budget that we received is only addressing our critical vacancies. They are not addressing all the vacancies in the NPA, but it is a big improvement. And so we are certainly able to do a lot more with the budget that we've received. But we would certainly urge that, given the impact of COVID, which has also resulted in enhanced demand for law enforcement services because of corruption in that space, that the budget of the NPA not be further cut, and also of the DPCI. I would urge that there be a strong case for the DPCI, in fact, being further capacitated to deal with this, because without their support and their ability to investigate these matters, it's extremely difficult. So I'm going to just leave it at that, and certainly we will take questions later, but I'm going to hand over to Advocate de Kock to give you some more details about this coordination mechanism. Thank you. Advocate de Kock.
Thank you very much, NDPP. Thank you, Chairperson and honourable members and colleagues. Chair, the presentation has been made available to the committee. Dr. Wells has covered most of the ground, in terms of the working relationships and some of the key issues that we are addressing going forward. We have collaborated with each other regarding our presentations. And so my intention is not to repeat what Dr. Wiles has already indicated to the committee, and we agree with the presentation that has been done by the SIU. In summary, there are 5 key objectives that we want to achieve going forward. The first is that we want to strengthen relationships and collaboration with our partners. That includes the DPCI, but more importantly, it also includes the SAPS detective services. And so we want to understand exactly what is happening in all of these investigations. We agree with the view of the committee that within the justice system, it is very important that we take action against officials who are It's unconscionable that state attorneys can collude with private lawyers in the manner in which they do. And so we must ensure that we demonstrate action in the courts where we find criminal activity. So the first one is in the strengthening of relationships between ourselves, DPCI, and the SAPS detective services. And then we have looked at the methodology, and that is what Dr. Wiles has explained to the committee, and strengthening the working relationships. And so what we found is that there is a bit of a time lag between matters being received at the national office, at the NDPP office, and getting those matters to the DPPs and getting them strengthen that time period within which matters and referrals are then made directly to investigators. So that's the second area. The third area is the MOU that we have under review. And here we really are encouraging the police to sign an agreement with us. And that is so important. Unless we all agree to the approach, we often find that people don't commit themselves or don't fulfill their commitments and their obligations. Under normal circumstances, it wouldn't be necessary to have MOUs. We have laws, we have a constitution, we have acts of parliament that indicates how we are supposed to work with each other. But from time to time, because of priority areas like the SIU, we need to ensure that we've got effective MOUs and ones that can speak directly to the operations of the respective departments. And so that is what we are now doing to ensure that this works. That's the third area. The fourth area will be a joint database between our respective agencies. Unless we have a common understanding of where all the cases are, what is the progress of the investigation? Have decisions been made in respect of cases to prosecute or not to prosecute? Is there unhappiness with that decision? Remember, the law allows anyone who's unhappy about a decision not to prosecute to raise concerns. And so that's what we want in terms of transparency, to make sure that our decisions as we make in the prosecuting authority are correct. And if anyone is unhappy about any decision we take, that we can follow a review process with that. And so the joint database will help us to manage these cases amongst all the other priority cases that we have within our spaces. The fifth area will be the coordination at a local level, at a regional level. This is where the work happens between SCCU offices of the MPA and the DPCI offices, and then of course the SIU project offices as well. And so there is coordination mechanisms that we are putting in place. There are existing mechanisms. We will strengthen that. We want our SCCU prosecutors to work very closely with our DPCI investigators and with our SIU colleagues in the regions. And we want us all to know that these cases are getting attention, that there will be a project management approach to the investigations, that we will hold our prosecutors and our investigators accountable according to timelines, that we will ensure that these issues are incorporated into performance agreements so that we can hold individuals accountable for the work that they do. So, Chair, that is in a nutshell the approach, and I'm just reinforcing what my colleague has already indicated to the committee. But I think I've taken it a little bit further to say that we really want to work on the nuts and bolts of making this thing work in cases and in courts. And from our side in the NPA, we will do everything in our power to ensure that those people who are corrupt within the system, particularly attorneys, that they are brought to book. Attorneys are a special category of people that act in the public interest. And so they will be on the radar on a list that will be on a national list and on a provincial list of cases. As soon as those cases are in courts, we will ensure that those cases get the necessary attention and that prosecutions are effective. I think in brief, NDPP, that is my contribution, unless there's anything further that you'd like me to say to the committee. Thank you very much.
Thank you very much, Advocate de Kock. Honourable Chair, maybe I will just note at this point as well, is that, you know, the two newly appointed Deputy National Directors, Advocate de Kock and Advocate Rabaji, who's also on this call, who heads up the Asset Forfeiture Unit, bring to the NPA a much needed injection at the leadership level to ensure that the cases get the necessary attention. And there's a lot that's happening already in that space. And certainly we hope that you, the committee and the people of South Africa will see the fruit of this as we report to you again, as the Honourable Chair mentioned, as the committee requires us to do. So that is a very, very important new development in the NPA. I also want to mention that we are looking at a project with the DPCI with regard to dealing with statutory offences, contraventions of the PFMA, MFMA. This has not been a top priority in the law enforcement space. And I know that Advocate de Kock is in the process of engaging with the DPCI or the detectives to make sure that these cases are, you know, dealt with. Generally, not always, are easier to investigate and to deal with. And one would imagine that the SIU investigations would reveal a lot of the evidence already in that space. And so to ensure that whilst the bigger cases investigations of corruption are continuing, that we are able to bring these cases, the statutory offences cases, quickly, so that there are consequences whilst the others continue. So that is another, hopefully we'll be able to report more positively to the committee when we next meet in that regard. Thank you, Chair. We're happy to take questions.
No, thank you very much. And once again, welcome to all the Deputy National Directors of Public Prosecutions that have been appointed. I will now recognize three hands, Honorable Glenis Breitenbach, Honorable Masek, and Honorable Swart. Please be very, very brief. By 1:30, we need to join the House, the National Assembly, and we still have one outstanding matter that we have not dealt with. Please be very brief. Honorable.
Thank you, Chair. I have one question. To both the SIU and the NPA, that sounds marvellous. I'm very happy that, as I'm sure everybody else is, that you are taking these steps to increase or improve relationships, because it's important. The tripartite agreement sounds great on paper, looks very impressive, sounds great. Best laid plans, however, mean nothing if you don't have anyone to execute them. So best laid plans on paper, who is going to do the prosecutions? Do you have the resources? But more importantly, you can prosecute nothing unless it's been investigated. Who is going to do the investigations? You can talk to the DPCI until the cows come home. They do not have capacity. How are you going to address that? I know it's not your problem, but if you're in a tripartite agreement, how is that gaping hole going to be addressed? The DPCI has no capacity. I can count the number of people who can investigate this kind of thing on one hand, I'll probably have fingers over. Who's going to do it? And how are you going to fix that?
Thank you, Chairperson. Can I come in?
Yes, thank you. Thank you.
Thank you, Chairperson. I just want to add also my voice in congratulating the new team, newly appointed team, and we hope that they will definitely work together in making sure that more progress, we get more progress. But I think I'm already covered, Chairperson, on the issue of the tripartite, the importance of that tripartite relationship. I was also going to mention that one. That we need to make sure that we tighten up that area, and you also inform us next time when you come back as to, have you met with the police? Do we have those people that will be dedicated into this a mandate where you always meet, you know, as a team, and then you plan, and then you come and report to us? That I wanted to say. But my questions, Chairperson, I think the questions that I asked Advocate Mutibi earlier, those questions belonged here. I think I'll listen, especially on page 66 and those number 6 and number 7. I think I'll listen. Thank you to the responses there. Thank you.
Thank you very much, Honorable Swart.
No, thank you, Chair. And also from my side, congratulations to the new appointments. Thank you, Advocate Patia, for being frank about the battle. The battle is ongoing, and we are trusting that we will together win this battle against crime. Can I just quickly ask you whether you've had, what are the impact of any budget cuts that have been proposed in the new budget? Give us an indication of that. Secondly, I agree with you on the PFMA. Bearing in mind the Auditor General has now got new powers as well in terms of the amendments to the Auditor General's Act. So that is an easy win situation. Thirdly, Chair, I would suggest that we meet with the Police Portfolio Committee to address the issues, and I'd be fully in agreement with the Hawks being involved in a memorandum of understanding as well. Then lastly, I'd like to get an understanding. Advocate Breitenbach refers to the investigation lack of capacity with the Hawks. Now, with the Bosaso matter, we saw the SIU presented a complete case, forensic investigations, and it sat for 10 years. Is it not possible that the SIU forensic investigations can be done in such a way that the cases are almost case ready in working with the NPA, that when they do the case, yes, we do understand the Hawks have to open a docket, but that the forensic investigations that the SIU is already doing, that they present a case ready as far as possible. The NPA and the Hawks can then say, they don't have to restart the investigations. And I'm sure they don't, but to try to cover the gap with the Hawks with forensic investigations, given the fact that the SIU is doing a lot of the forensic investigations already, is that not a way? Do we need duplication? And to what degree are the Hawks and the NPA able to rely on the forensic investigations by the SIU? Thank you, Chair.
Thank you, Honorable Advocate Mutibi.
Very much, Honorable Chair. We were really encouraged by the support from the committee, but we do agree with Honorable Breitenbach that you can have a plan, but if it's not executed, then it's really not worth it. So in the MOU that we have built in a monitoring mechanism, so that, and that's why we indicate in the presentation that there's monthly meetings that happen amongst the parties, and we are really committed to making sure that we monitor this arrangement so that it brings out the results that we are looking for. The tripartite relationship, it really came up after exactly the point that the committee is mentioning, particularly what Honorable Swart indicates. When we investigate, and that's why we keep mentioning the evidence pack when we presented earlier on, that we do collate as far as possible the evidence that would point to a crime that is being indicated. We do understand that obviously the NPA still have to apply their minds and make sure that the evidence is ready to be prosecuted. Yes, there were issues of dockets being opened, and I think as part of this mechanism, when we bring in DPCI in the MOU, that part is going to be really addressed because it also will assist if that opening of a docket part is addressed as early as possible. So we've had an engagement with NPA around the evidence that we put together and refer. So we, as part of this mechanism now, we'll probably have to have an opportunity where we both and the DPCI, where we agree the extent to which the evidence that we bring is either case stroke court ready, and how is it that we can obviate and eliminate this possible duplication. In the past, there was a view that SIU's evidence is collected mainly for civil litigation, but I think we have put our case across that when we find evidence that points to the commission of an offense, we do also put that evidence together. So it's really something that a matter that as tripartite we'll need to make sure that that is addressed and addressed conclusively to avoid duplication, and this is going to afford us to deal with these matters speedily. Yes, Honorable Jele, we agree that we need to tighten the tripartite arrangement. The issue around the investigation capacity on the part of DPCI, that indeed needs to be attended to. But if we can have that tripartite tightened and we are all on one page on how to deal with the evidentiary part, because more often is the one that really delays the process. NDPP, I really agree that we've been questioned at various instances. I recall in our previous appearance in the committee and at SCOPA that as ACTT, also just generally, we have been questioned that there has never been, a demonstrable prosecution around PFMA or MFMA. So we are really glad that that part will be attended to, and we will support as much as we are required to. Thank you very much, Honorable Chair. I think I've at least responded from our part. I'll hand over to NDPP if you've got responses.
If I may, Chair. Thank you very much.
Yes.
Chair, the first question by Advocate Breitenbach, that is really the crux of the problem. That is it. It's the capabilities and capacities of the state to deal with this huge challenge that we are facing. And unless government deals with this in a very, very serious way, we are not going to be able to win and fight this battle and win it. The way we are citizens of this country like you. We want to see these cases coming to court. We want to see people being held accountable. We are outraged by what has been going on. And we are in the system, realizing the huge challenges, but not giving up, not by any stretch of the imagination. We are here to fight until the very end. The point is, if you're right, if you can have all of these great policies, all of these great strategies, it's in the implementation. And if you do not have capacity and capability, no matter how well intentioned, you're not going to succeed. Now, the issue of the capability of the DPCI is indeed a big challenge, and that sits outside of our responsibility. But we are working. General Labia is an honorable man, and I have incredible respect for him, and we are working so closely together. But I share his. I want to speak on his behalf to say, help capacitate the DPCI if we want to win this battle. We have, we cannot forget what has happened over the last 10 years, and we are now very short into trying to rebuild this country. And if we don't address these serious capacity issues in key agencies like the DPCI, we are not going to win this battle. And so as we move forward as a country, we also really have to seriously start thinking about what is the best way to deal with corruption on a big scale. What is the best way for how does the state organize itself to do this? Because the methodology of separate police investigations, separate prosecutions coming in, guiding, it's not the best way. The directorate has been set up, also has challenges, various challenges. That's a temporary mechanism. As a country and as a Justice Portfolio Committee, perhaps, there really needs to, and the Zondo Commission will perhaps make recommendations, but we really have to think, what are the capabilities that are needed by the state? Does the state have it? And how do we ensure that we're able to properly address this? So there are serious issues within government and law enforcement, but we are really doing our best to work within those constraints. But government really needs to assist with capacitating. I mean, the forensic accounting capacity, which was mentioned, government is spending billions and billions of rand making forensic accounting firms rich on forensic accounting reports. Many of them are not sufficient for prosecution purposes. So, we really need to look at, do we need a capability like that in government? Because there's so many different entities that require these services. So these are really the questions that we need to be asking us and looking, because it's all very well, we will come here and report, and there will be cases, and we will be making improvements. I am confident that that will happen the next time we come here. There are really good people working, but there's a much greater problem that government needs to be looking at. And so, I don't think I've answered your question. I've raised more questions than answers, but it's something that we really need to look at in terms of the capacity and capability of state to deal with this. On the issue of the Honorable Swart's question of the impact of the budget, at this stage, as I said, we have a critical budget for critical vacancies. We do need more in terms of capacitating and really skilling prosecutors to deal with these complex cases, corruption cases. So there's a lot of capacity building that's needed. But what I can say for now is that we think we have sufficient to at least get the numbers in, and so we are building. But it's certainly at the moment, the impact of the budget we have not really felt it. We certainly hope there won't be any further cuts because of COVID, but my understanding is that the NPA will not suffer any further cuts in that regard. And I will just ask Advocate de Kock to quickly deal with the forensic investigations. I think I've touched on it, but what I should perhaps also say is that between the DPCI, us, and the SIU, we do want to actually look at taking one or two cases where, because there is a bit of maybe this is a public space. I shouldn't say too much about it, but we do want to take test cases to court where those trial-ready matters can proceed quickly. But I don't want to go too much into the challenges on that. But there are some we are looking into that. So, Advocate de Kock, any quick points on the forensic accounting question or the forensic investigation question? Thank you. Thank you, Chair.
Yeah, the first is just that on the forensic investigations, we are going to work much closer with the AFU as well to bring the AFU into the support around these matters. And I think, Baba, you see, once we pool our resources, and not work in a silo approach, then automatically we're going to deliver better products. And so I think that is going to be central to the way in which we want to work. Create a collaboration with each other, strengthening each other, support for each other. And then we shorten the time periods within which things are supposed to happen. So I'm sure it's going to work. We see the results already coming through in the Fusion Center model that we have introduced, where we're working much closer with each other. So I think we're going to take some of those best practices and introduce it into different environments. But then on some of the proposals around the investigations, yes, I think that we can, as part of the agreement, look to how we strengthen the quality of the products that we get, both from the DPCI and from the SIU. And if there's ways to short circuit some of the work that the DPCI has to do, then I think that's also an area that we're going to look at. And I agree with everything the NDPP said about the accounting capacity within the state. That is an issue that we are discussing with the DPCI to strengthen them as well. So the DPCI is making commitments around the priority cases. They are in discussions with us regarding the resourcing issues that they have within their environment. And we are strengthening the capabilities of the SSCUs to put additional prosecutors. So as we speak, we are filling the vacancies in that environment, and we have already made a number of contract appointments in our respective SSCUs. So I think resourcing is critical, but it is something that we are working on. And hopefully at the next report to Parliament, we'll be able to provide more detail on the progress on that. But NDPP, I think perhaps the AFU maybe just want to add 1 or 2 points on this, because I have referenced the AFU, and Chair, we have referenced the AFU to all of this as well.
Honourable Chair, if you'll allow Advocate Rabaji 2 minutes as a new DNDPP as well, perhaps.
It should be strictly
Chair and honourable members, if I could come in, Chair.
Sorry, ma'am, before you proceed, honourable members, we must not approach this as the last time we are having a discussion on this matter. We are still going to have a lot of other briefings on this matter. So I will just allow you strictly 2 minutes, ma'am.
Thank you. Thank you, Chair. Advocate Rabaji.
Yes, thank you, Chair, honourable members, NDPP and colleagues. Chair, I can confirm without fear, favour and prejudice that we will be working together within NPA, in particular with Advocate Rodney de Kock. We've had discussions that we're always going to work from one framework. We'll always have one point of reference, and indeed in NPA already, I have capacity. I've got one person who's looking at all the cases that NPS has on the database. So we've got one database, we're working together, and we're going to move jointly and swiftly on all cases that are ready, either for preservation orders or restraint orders where prosecution is involved. So I just wanted to give the Chair and honourable members that we've already started work in this regard. We've also started work with the other colleagues in the joint sittings that we have with SIU as well as Commission General Libya, and that I think we'll be able to move swiftly. And the Fusion Center, the one case that we did from the Fusion Center is an example of that. Thank you, Chair and honourable members.
Thank you very much, Chair, for that. I should add that the Financial Intelligence Center is also working very closely with the FI, with the AFU. Thank you, Chair.
No, thank you very much, and thank you for this briefing. We are going to be having 2 briefings a year to get progress reports on these matters, and hopefully the next briefing, the DPCI will be part of the briefing of the briefings, we take this matter very seriously, and we think that if people know that because of the lack of state capacity, there would be no repercussions, then they will always have an incentive to act in a criminal way. So we are very serious as a committee to ensure that we fight crime and corruption in our country, and we will ensure that in every 6 months you will be invited to give a progress report which will be seriously interrogated. What we have learned from this engagement is that next time we would not make you to share time with other people so that we can have enough time, probably half a day, for you to give us a progress report. But we thank you for the work done and for the intentions that you have really articulated. Part of a serious challenge that is facing the state, especially the South African state, is that in most countries you have one republic, be it a People's Republic of China or whichever country, you have one republic. But in South Africa, every entity and every department sees itself as a republic. And this is what we must defeat. Because the 42 republics that we have create a lot of inefficiencies. And those inefficiencies are a breeding ground for crime and corruption. So thank you very much, and honorable members. Thank you for Advocate Mtibi, Advocate Batoi, and your respective teams for the work done. You must always know that the committee is behind you, not uncritically.
Sure.
We will pinpoint where we think that things can be done better. But that will be done with an intention to add value to your work, because your work is South Africa's work. Thank you very much.
Thank you very much, Chair. I feel confident we will win this battle, but it will be a tough one. Thank you, Chair. We appreciate the support and also to hold us accountable. Thank you, Chair.
Thank you very much.
Thank you.
Thank you, team.
Thank you.
Thank you very much. Thank you.
We
will be leaving now, Chair. Thank you.
Yes, thanks. Let me take this opportunity to welcome the South African Human Rights Commission and the Information Regulator, and apologize for the delay. It was an intense discussion that we have just had, and also welcome the Deputy Minister, Honorable John Jeffrey, who is part of this meeting. As we know that he was one person who was leading this process and the progress that we'll be receiving today. Advocate Trakola, welcome. I can see Advocate Tipenyana is also leading the South African Human Rights Commission's delegations. On that note, I had asked that I be released to attend the meetings of the chairpersons with the House Chair to deal with the budget processes. I would ask Advocate Mohammed to chair the meeting. Thank you very much.
Thank you very much, Chair. I hope I'm audible to members. That is fine. I think we have the delegation present. We must just indicate through the system. I can just introduce the fact that the Information Regulator, as we all know, is as a result of the POPI Act. And the POPI Act basically gives a dual mandate in terms of the responsibilities that is contained in terms of the POPI Act and the Promotion of Access to Information Act in itself. And we have seen the pronouncement on the 17th of June by the President that through a proclamation that certain sections will come into effect. In fact, tomorrow, the 1st of July, if I remember, and then the rest of the sections, I think section 110 to 114 will come into effect on the 30th of June next year, 2021. And so when we were last year, Advocate Lakula, you mentioned, you highlighted the urgent need, of course, to bring POPI Act into full effect. And we are here today, of course, to get a briefing on the readiness of the Information Regulator as far as these responsibilities is concerned. So let us immediately, maybe you just want to introduce the delegation and we will then proceed. Welcome also to DM. Thank you.
Thank you very much. Yes, thank you very much, Honorable Chairperson, team. And good morning to you and to all the honorable members. And good morning to the Deputy Minister of Justice and Constitutional Development. I am here with the members of the regulator, myself, the chairperson, Mr. Snail Kamduze, part-time member, Ms. Advocate Strom Nzama, a full-time member designated for Popia, Advocate Colin Weapon, a full-time member designated for PAIA. Also the CEO, Mr. Max Tibela. And with your kind permission, I will ask him to introduce the executives who have joined this call. Chairperson, thank you.
Thank you. Please proceed.
Okay. Yes. Good afternoon, Chairperson, Acting Chairperson of the committee, and honorable members. And with the permission of our Chairperson of the regulator, I would like to introduce the executives that are also joining the meeting. We have Advocate Debo Kilautri, who's responsible for PIA. Then I have Mr. Nchumbezeni Nemasisi, responsible for PAIA. And we have Ms. Vasha Sulal, responsible for legal policy research and information technology analysis. We have Mr. Prakash Narismulu, the Chief Financial Officer, and Ms. Helen Shube, the Executive for Corporate Services. Thank you.
Chair, I think you are muted.
Oh, sorry about that. I was saying that we are ready for the presentation. I just want to check, DM Jeffrey, do you want to do any introductory remarks on your side at this stage?
Chair, I'm fine.
Okay.
I everybody knows, well, as you've said, the remaining sections of PAPIA come into effect tomorrow, bar section 110 and section 1144, which is in agreement with the regulator. So let's leave it like that. Thanks.
Thank you very much, Deputy Minister. I think you can proceed, Edward Lakula.
Thank you very much, Chairperson. Really, the presentation consists of 5 sections: the introduction and the matter that we have just covered, being the proclamation that has been issued to bring the remaining sections of POPIA into effect. And then we have a slide that will deal with the establishment of the administration and funding requirements, then the POPIA readiness plan and the PAIA readiness plan. So I will not go into detail with the introduction, Chairperson, just simply to say that after our last meeting, the last presentation that we made to the committee, we in fact met with the Department of Justice and Correctional Services, as the Deputy Minister had undertaken to do. and we discussed the coming into effect of the remaining sections of POPIA, and what was proclaimed by the President was as a result of the agreement between the Information Regulator and the Department of Justice. We agreed also, which is very pleasing, that the proclamation will in actual fact contain the date for the coming into effect of section 1110 and 1144, so that we don't have to start the process all over again next year to go back to the department and to the President. So we are very pleased with that, so that we all know that we are working towards a deadline of the 30th June 2021 for PAIA to come into operation. And also just to mention that, as you know, Chairperson, the remaining sections that have been brought into effect, which is 2 to 38, 55 to 109, 111, 1141, 2 and 3, although they are coming into effect tomorrow, private and public bodies will have up to the 1st of July 2021 to ensure that they put compliance mechanisms in place. And the Department of Justice will be working hard towards between now and the 30th of June 2021, as far as PAIA is concerned, to ensure that all the regulations that are required and all the laws that have to be amended are amended, so that when PAIA comes into effect, all those amendments will have been effected. And according to Section 1144, the South African Human Rights Commission will transfer the PAIA function to the regulator as soon as reasonably possible after the 30th of June 2021, which is the date on which 1144 of POPIA will come into effect. I will stop here. I'm mindful of your time constraints, Chairperson, and I will hand over, with your permission, to the CEO to present the next slide. I just want to thank the Deputy Minister of Justice for really supporting us and ensuring that the Act comes into operation. It's been a long journey. It has been a lot of pushing, but eventually we have succeeded. Thank you, Chairperson.
Sure. No, thank you very much. Let's proceed.
Okay, thank you, Committee Chair. Okay, I'm just trying to. Yeah, I'll then present the summary of the positions that the Information Regulator has identified in its organizational structure in order to ensure that we implement both POPIA and PAIA. And I'll start from slide 10. Then, yes, I'll start from slide 10 and just highlight from, POPIA, what are the provisions as the regulator. Then section 47.1 provides for the regulator to establish its own administration. Then section 47.4 talks about the regulator. It states that the regulator may pay persons in its employ such remuneration and allowances and provide them with such pension and other employment benefits as are consistent with that paid in the public sector. Then section 47.5 is the most important one, because it now requires that the regulator, in the process of establishing its administration, must consult with the Minister of Finance. So what has been happening, honorable members and the Deputy Minister, is that since 2018, the regulator has engaged with the Minister of Finance, wherein a top structure was presented and a business case, and it was agreed from that meeting that the regulator will fill its positions within its structure on a phased-in approach. Then now I'll quickly talk about the summary of positions that we have identified. Since then, the regulator has identified positions both at head office and provincial offices, and the total number of all the positions are 378. Then we went on to do a costing for these positions. What we first did was to break down these positions into phases, and which also look at the medium-term expenditure framework period. So the summary that is shown on slide 12 indicates that from phase 1, which was in 2019-20, we had 13 positions. Mainly it was the CEO and executive positions and the administrative assistants. Then all those positions were filled by 31 March 2020. Then we are now on phase 2 during this financial year. We have 18 positions that we have identified that are funded. Then to date, we have already filled 4 of those positions. Then due to COVID lockdown, we couldn't move with the recruitment process, but I'm glad to indicate that as we are presenting today, we are in a process of also filling about 6 positions. And there are others that we had to re-advertise because the response was not that good during the lockdown. Then phase 3, these are the positions that now will come in. Mainly, they will look at the core business. We have 4 core business divisions. It's POPIA, it's PAEA, it's education and communication. Then it's legal policy research and information technology analysis. So majority of these 95 positions will be to staff the organization so that it can fulfill its mandate. Then we have phase 4, which is the remaining positions at the head office again, which looks at some of the core business and also the support within your finance and HR and other areas. Then phase 5 is mainly the provincial offices. Then with 189 posts, then it brings to that total of 378. Then on the next slide, we're just showing the summary of the budget that we had during 1920 and what was set aside for compensation of employees for the 13 positions. It is important to note that this amount also includes remuneration of the members of the regulator. Then the next slide, which is phase 2. This is the 18 positions that I mentioned. The employee compensation budget sits at 32.251 million. And this includes the 4 positions that we've already filled that I indicated and also the compensation for members. Then the budget, when you look at goods and services, also including machinery, sits at 45 million. Then phase 3, this is where you start now seeing gaps that, in terms of the budget, the indicative allocations that Treasury has confirmed in November last year for 3 years, that the budget moved from 32 to 45. Now it will go to 57, inclusive of the goods and services in 2020-2021. But the challenge there is that when you look at these numbers now cumulatively, the 13 plus the 18 in phase 2 now making it 126 when you add now, from phase 1 and 2. So you can see on the 3rd column that the post will go to 39, of which only 8 will be funded in phase 3. So, and there is 87 positions of the 95 that I mentioned earlier that are unfunded. And then now we are showing the budget shortfall there on column 6, that for us to fill these 87 positions, we will need 59 million, which is currently not allocated. And we also did a projection of the goods and services, looking at what is currently allocated in 2020-2021, and the shortfall there on column 6 of 19 million. Then machinery and equipment, what is currently allocated for 2021-22 is 4.3 million, and we'll have a shortfall of 6 million. Then the next slide goes to phase 4. Phase 4 cumulatively now will have 189 positions, which are all the positions now at head office. And again, we are showing on column 3 that only 39 will still be funded, which is the numbers coming from the phase 1, 2, and 3. Then the budget increased slightly on the compensation of employees from 40 million to 45, which can only allow us to fill 2 to 3 positions. Then now the number of unfunded positions cumulatively now is 153. Then the shortfall will be 96 million. Then when you look at the goods and services, what is provided for 22-23 is 13 million. There's a shortfall of 31 million for goods and services. Machinery and equipment allocated 4.7 million. There's a shortfall of 10.3 million. Then phase 5, this will be the provincial offices now. When you add the 189 at head office and the 378 at provincial level, then this is the total staff complement. Again, we are showing that for that year now, this is outside the 2022-23. So then 23-24, currently there is no allocation that has been confirmed. But what we did was just to put an inflation kind of increase to show a forecasted amount to say. Then for compensation of employees, if we look at the numbers, it will move from 45 to 47. And now the number of unfunded position will be 342. Then the shortfall for compensation of employees will be 314 million. Then the goods and services will move from 12 to 14. This is the projection that we have made. Then there will be a shortfall cumulatively of 68 million on goods and services. Machinery and equipment, 4.9 million. And then the shortfall will be 22.9 million. Then cumulatively, the shortfall that we calculated based on our projections is 306 million. So it shows that in 2023-24, if we add that inflationary increase, our budget will sit at 66 million. Then the next slide just shows a summary cumulatively of what the regulator will need. The shortfall from 21-22 financial year is 84 million. This includes your compensation of employees, goods and services, machinery and equipment. For 2022-23, it will be 138 million. Then 23-24, 306 million. Then the next slide talks to the detailed readiness plans that the chairperson of the regulator was talking about. Then I will hand back to our chairperson to deal with this slide. Thank you.
All right. Thank you. Chairperson, Advocate Lakula.
Thank you very much, Chairperson. I just wanted to get an indication whether you want us to proceed or you want to take questions, or you take questions at the end.
Yeah, which part is, are you done with the HR readiness presentation?
Yes. Yes.
Okay, maybe. Yeah, I was wondering maybe we should proceed unless there's a few questions at this moment, members. Do we rather proceed with the whole presentation and then we ask the question as we normally do? I think maybe we should proceed and we hold the questions for later.
Okay, thank you, Chairperson. The next slide, I will also give a summary of that because
so just before you proceed, I had a hand earlier of Honorable Horn. Sorry, I didn't see it because we're on this new program. I'm so used to Zoom. Honorable Horn and Edward, also Honorable Wilma Drachen. Is there something that you wanted to ask at this stage on the process?
Yeah, it's Werner Horn speaking, Mr. Acting Chair. I'm prepared to wait till the whole presentation has been done.
Sure. Thank you. Honorable Wilma Drachen.
Good morning, Chair. Yes, I will wait until the end of the presentation as well.
Oh, sure.
Thank you.
Let's do so. Thank you very much. You can proceed, Advocate Lakula.
Yes, thank you very much, Chairperson. The presentation that we are going to make on the readiness plan for POPIA, it will not be possible for us in the time allocated to do the whole presentation. I think what I need to do is to just explain how we came up with that readiness plan for the implementation of POPIA. What we did was to look at each and every section of POPIA to see whether there is any implementation action that we need to take, whether it is in the form of a guideline, in the form of a regulation or in the form of an interpretative tool. So we went through that exercise. We've been going through that exercise, and what you will see really is really the outcome of that analysis, which is a very thorough analysis. I can just, for instance, point to some of the sections in this long document. As you know, Chairperson, the Act provides for 8 conditions for lawful processing of information. And I think on our side, for internal purposes, we have been interrogating the meaning of these 8 conditions, but in some instances, we will need a guide. For instance, the Act provides that private and public bodies should put in place adequate security measures, which are technical and organizational, for the lawful processing of personal information. Internally, we'll have to come up with some sort of guide for ourselves to say what constitutes adequate technical and organizational security measures, because this Act is new and we will have to develop as we go. For instance, I can give you another example, which is probably a little bit controversial. If you look at exclusions in Section 6 of the Act, it talks about personal information that is processed by a public body, for instance, in the interest of national security, will be excluded from the Act. But the Act does not tell us what constitutes national security. So we'll have to sit down and sort of see what are the parameters of national security, so that we don't have a situation where everything is included or a very wide definition of national security is given. It's the same as public interest. The Act mentions public interest in quite a number of instances. And of course, we think that the interpretation of public interest will be on a case-by-case basis, depending on the section that we are dealing with. For instance, if I give another example, in the exclusion, where the Act also provides that it will not apply in cases of information that is published, that is processed for journalistic, literary, artistic purposes. And the public interest issue also comes up there, because in terms of Section 7.2 of the Act, it specifically provides that if a code, for instance, it provides that the Act does not apply to the processing of personal information for journalistic, literary, and artistic expression, to the extent that such exclusion is necessary to reconcile, as a matter of public interest, the right to privacy with the right to freedom of expression. So we'll have to do that balancing act to see, whether in certain circumstances, public interest trumps privacy. And for instance, the press code, the Press Council has already given us their draft press code, and we are looking at it to see whether it contains adequate safeguards for the protection of personal information. Some of the work that is mentioned in this long document, we have already done. For instance, to give an example, you might be aware that we drafted the guidelines for codes of conduct, because according to the Act, private bodies and public bodies can adopt their own codes of conduct on how they're going to be processing personal information. And the Act provides that we, as the regulator, must come up with guidelines on the development of codes of conduct, so that these guidelines can then guide the bodies in the development of their codes of conduct. We have already done work in that regard. We, as you know, we did draft the guidelines for codes of conduct ourselves, and we have subjected them to consultative more than comments from a number of interest groups. And we are in the process of looking at each and every one of those comments. And some of them will be incorporating, others not. But in the interest of fair administrative justice, in instances where we are not going to be incorporating or taking into consideration any comment, we have to give reasons why we are not doing that. This is tedious, but we think in the interest of transparency and fair administrative justice, we have to go through each and every comment. The Act also, for instance, it obliges the information officers to be registered with the Information Regulator before they can start functioning. And we have already developed a guideline for the registration of information officers. You would also know, Chairperson, that we have already done the regulations, and now that the Act has come into operation, or it's coming into operation, those regulations will also be coming into effect. So, Chair, like I said, maybe I'm hoping that the members have been able to read this document, because we sent it before in advance, and I just feel that it will not. I won't be able. I can't go through. I can go through it if you want me to do that, but maybe, Chairperson, with your guidance, maybe we can take questions on this long document if members have had the opportunity to read. And then Advocate Strom Nzama will present the readiness plan, a summary thereof for the implementation of PAIA, with your permission, Chair. Thank you very much.
Yeah, no, I agree with you, Edward Akula. It's not necessary to proceed further on this part, except to get the summary of the operational plan. We have read the document, and we obviously would be probing some of the issues to be clarified. I mean, there's a number of issues here already. The issue of independence. We don't want early on any litigation for pay to be taken to court because you are still in the Department of Justice in one of the entities because of budget structural issues. The whole issue of prescribed fees is immediate. Basically, as sections come into effect, whether that has been complied with, the education with regard to what is lawful processing of personal information, the public will need to know. And then more medium term, which is actually short term, your MOU with regard to the PAIA, that is for next year. But let's take the operation summary for 5 minutes or so, and then we will immediately move to questions, if that's okay. I've listed already a number of issues, but you can proceed.
It's Advocate Strom who has to talk about PAIA.
Oh, okay. Advocate? Yeah.
Thank you very much, Honorable Chairperson of the committee and honorable members of the portfolio committee.
Is it Advocate Strom speaking now?
Yes, am I audible?
Oh, I didn't see you. I just hear you, but that's fine. You can proceed.
Okay. Thank you very much, Honorable. Thank you, Honorable Chairperson of the Portfolio Committee and honorable members. Thank you very much, Advocate Lapula, for giving me this opportunity to present the overall overview on the PAIA readiness plan. Chairperson, I'll start firstly by explaining that currently, before the promulgation on the 17th of June, we have been engaging regularly with the South African Human Rights Commission in terms of, we have an MOC in place in terms of those transitional arrangements for the handover of this PAIA function. And we have noted that since now the section 1110 and 1144 has been going to be effective on the 30th of June 2021, we need to have something in place now currently because of that. So we sort of propose on the readiness plan that we have a plan of action with the South African Human Rights Commission in terms of come 30 June 2021, we are ready to take over the PAIA function. Chairperson, if you go through the plan, it's very detailed, like the POPIA one. It's similar in terms of approach. We looked at the current provision of PAIA as amended by POPIA, and we looked at what the effect of the amendments will have on PAIA. And for an example, the new sections which will come into operation, it will be section 77 capital A to 77 capital J. We looked at it, it's on page 23 of the readiness plan. We also looked at the detailed action to be undertaken on each of the provisions of PAIA. And we have since also identified sections where we'll need regulations to be in place in that regard, because the Act will talk about as prescribed, so we need to regulate again. Now, our approach in terms of PAIA and POPIA is the same. However, Chairperson, at this point, I just want to say that we need to also start having those engagements, robust engagements with the Human Rights Commission in terms of the readiness. Now, in terms of what plan of action we have, so that come June 2021, we are ready as the regulator to take this PAIA function. But Chairperson, if the volume of the document is very big, so if you look at the document, you'll see that we have outlined how this will impact on the operationalization of the regulator taking into effect PAIA. So Chairperson, I think I've given a high overview in terms of the approach, and it's detailed on the plan itself. Chairperson, I think I'll stop there and give other meeting members an opportunity to add on the PAIA readiness plan. Thank you, Chairperson.
Right. Is there any additions from the team? Advocate Platkula, is there any additions from the team?
I don't think so, Chair. We are mindful
All
of
right.
the time. We should just take the
That's fine.
questions with your permission. Yes.
No, thanks. Thank you very much. Okay, members, there we have it. As I said, there's a number of issues here. You can just show by hand also, because my screen keeps turning around. But there's a number of issues in terms of that operational plan for readiness. I listed some of it already in terms of the HR various phases, as we saw. I wasn't, maybe at the end of the question, you can also answer, Edward Lakula, which phase has been approved by the Minister of Finance. You indicated each of these phases we will seek a mandate or approval from the Minister of Finance for your establishment. And each of the phases you listed a number of posts. You can just indicate which of the phases has already been approved. I assume phase 1 and 2 is approved, that's why you advertise, but indicate the status of phase 3 and 4 perhaps, right? And then of course, you would want to elaborate also on the whole issue of the budget that's located still in the vote account of DOJ and what is being done there, as well as the promotion of what is lawful processing of personal information. But colleagues, let me give over, allow you to ask the questions. I think I've got Honorable Horn first, and then Honorable Wilma Drachen. You can proceed, Honorable Horn.
Chair, can I suggest something? Chair?
Where am I speaking now?
Can I suggest something?
Yes.
Chair, noting the time, and some of us need to step out of the meeting for the preparation of the next meeting. Is it possible we can send our questions? Because we are not going to really do what we want to do with this justice to the whole report. I want to welcome the report, but at the moment, I don't think we'll be able to ask questions as we wish.
No, sure. We will proceed for the next 25 minutes and then conclude at 1 o'clock. As some of us have to physically get to the house, which is a bit far from where we have to drive. But let's proceed. Thank you, Honorable Mofokeng. Certainly the questions can be sent so that the Information Regulator can respond accordingly. Let's proceed, Honorable Horn.
Yeah, thank you, Mr. Acting Chair, and mindful of time, I'll try to keep it brief. In connection with your question on the phasing in of filling of posts, I think what we also need from the Information Regulator in terms of readiness is a detailed breakdown as to how many of the phase 3 posts will be essential to perform both the functions in respect of POPIA and the functions that's now to be due to be taken over from the Human Rights Commission in respect of PAIA. Previously, Advocate Lakula has said when we raised this issue that if necessary, the commissioners and the executive will also get down and make their hands dirty with dealing with complaints and these issues. But in an ideal world, we want to know what is the baseline, the bare minimum with which the Information Regulator will be able to perform these functions, specifically also given the big unknown in the coming years in respect of budgeting. And then, Chair, having said, the only other question I will stick to is the issue on the operational readiness plans. And we see that in respect of more or less everything, there's really long-term timelines. 2024 is mentioned, and in respect of, for example, educational programs, 2022 is mentioned. And I think from our side that must make us a bit nervous about the ability of the regulator in 12 months' time to really deal effectively with complaints, specifically on POPIA's side. And there's this big danger. You already referred to litigation. The other big danger is that if they will not be able to assist the public or institutions effectively, then very quickly a perception might be formed that they're just a paper tiger. So I think from our side, we must urge that these timelines must be shortened and that we quite possibly within 3 or 4 months must reconvene with the Information Regulator and insist on a plan that will make them operational by 1 July next year. Thank you.
Thank you very much, Honorable Horn, for raising that. Honorable Drachen, Wilma Drachen.
Yes, thank you, Chair. And be aware that I will also be leaving at 1 o'clock, so I'll catch up on the responses later. Just 2 things. I see that you give in the budget, there's only 3 things: the compensation of staff, goods and services, and machinery and equipment. I don't see a budget for your 378 staff officers. Where will they be accommodated? So I just wanted the total amount of what you are going to spend on rental or office accommodation. So that's the one. My second question is the impact of COVID-19 on your budget, the total budget. What was the impact, the money spent, and then also the impact on that? So only those 2. Thank you, Chair.
Thank you, Honorable Drachen. I'm just checking if there's anybody else. I noticed that Honorable Breitenbach has indicated she will submit written questions. I don't see any other hand on the system, unless you can indicate verbally. If there's any other questions? Okay, colleagues, it looks like we're all in a hurry. But
we shall.
Sorry, who's speaking? Honorable Jele, are you speaking?
I'm covered, Chair.
You covered, you sure? Okay.
Yes.
Okay, it looks like what we have is we looked at the plan, and based on the question that has been raised, there's a concern about the timelines. One can understand that you also dependent on a number of administrative processes. I just wanted to point out despite the seeking of independence, that sharing of auxiliary resources of the state does not impede necessary on independence, such as office accommodation, etc. As we know, it gives one a lot of memories when we started with the SIU, even the then Scorpions in the NPA itself, in 1998, somewhere there, then also utilize in the first 3 years accommodation and facilities of various departments. So you may have to go that route given the budget constraints itself. But let's give yourself a chance to just respond to some of the questions that has been raised and the issues that I've listed. Thank you, Edward Klakulo.
Thank you very much, Chairperson. I will respond to some of the questions. The CEO and my team, my colleagues will respond to others. Regarding the question of the separation plan, we do have a separation plan from the because we have to separate from the Department of Justice in order to ensure our independence. We do have that separation plan, and the separation plan talks mainly to financial separation. What policies do we need in place to ensure that we can operate on our own? So that separation plan exists. What we are doing now and what we have done, we have written to National Treasury to say to them, these are the policies that we need to separate from the Department of Justice. We want their confirmation and their advice as to whether those are the policies that we need for internal controls. So that we have, Chairperson. On the issue of accommodation, you know that we have taken a strategic decision that we will continue to share offices with the South African Human Rights Commission, that we will be doing joint procurement of the office accommodation. We have also approached the National Treasury to advise on how the joint procurement for office accommodation can be done. And for Honorable Horn, I can assure you that we do have prioritization of the posts in question, even after the promulgation by the proclamation by the president. We actually even reprioritized some of the positions, and we will keep on doing that. And because, as you correctly point out, money is very difficult to come by, we will have to approach the minister. The Deputy Minister of Justice has been trying to assist us to get an appointment with the Minister of Finance. It's very difficult to do that. And he actually even advised that maybe we should see the Deputy Minister of Finance, because indeed it is phase 1 and 2 that has been approved. We still have to go to phase 3, 4, and 5. And even that, I mean, we are prepared to look at those positions. What we have presented is the total organizational structure in an ideal situation. And of course, we'll have to look at it to say, taking the budgetary, the financial constraints that the country is faced with, which of those positions are at a bare minimum. So we will be doing that. I don't know, colleagues, you can take some of the operational readiness plan. Is it long term? It's not all of it. It's long term, really. There are things that we have to do now. For instance, the complaints, which is an example that Mr. Horn gave. As you know, we already have a manual complaints management system in place, which we are using. We are in the process of procuring an electronic complaints management system for us to be able to take the complaints. So there's some of the things are already in place. So, I mean, we are taking complaints. We have been taking complaints. It's just that we now need an electronic system of complaints. And regarding education programs, one of the senior positions that we're going to be advertising is for the Executive for Education and Communication. And once that person is on board, we will be able to, do our education programs in a professional manner. Most of us are lawyers. And Mr. Horn is correct. We are doing everything ourselves. We don't. It's in there. We have not outsourced anything except maybe the court case that where we were cited as a respondent, or where we applied to be an amicus. But if you look at everything, and I keep on saying, the regulations we drafted ourselves, the guidelines for development of codes of conduct, we drafted ourselves. Even the guidelines for the registration of information officers, we drafted ourselves. At the moment, we are looking at consulting the health sector on coming up with rules to regulate the health sector. We are doing that ourselves. We've just had a meeting with the National Consumer Commission regarding direct marketing. All that were the analysis of our act vis-a-vis the analysis of their act regarding direct marketing for unsolicited electronic communication. We're doing that work ourselves. We are now even doing the whole issue of processing of personal information as it relates to surveillance. So there are issues that we have prioritized, and our priority is informed by the complaints that we receive, because from the complaints we can see the sectors where there is unlawful processing of personal information. And in our approach, those are the sectors that we have prioritized. Chair, I can give to the CEO with your permission, or let me see if my members want to add, and then the CEO can then respond to some of the questions. And we welcome questions in writing, Chair, and we will be responding to them. Thank you very much.
Thank you, Advocate Lakulo. Is there any other member of the team wishing to respond before the CEO?
Chair, yes.
Yes.
Advocate Colin Weston, if I may.
Yes. Advocate, proceed.
Good afternoon to you, Chair, Honorable Chair, and Honorable members. Good afternoon to colleagues. Good afternoon, Chair of the Information Regulator, as well as the Deputy Minister. Chair, with reference to the issue of how ready are we to actually implement the functions of PAIA and POPIA. And our chairperson is very correct to say that we have been doing a lot of the work ourselves, but as you would know, from phase 3, 4, and 5, we would be grossly or to every extent be dependent on the budget that we will be receiving from National Treasury. So as such, I think Chairperson of the Information Regulator and Honorable Chairperson of the Portfolio Committee, we cannot stress the importance of us ensuring that there's sufficient budget available as per the CEO's plan of recruiting 378 members of staff. But that would be one of our most critical dependencies in order for us to fully operationalize the Information Regulator. That's the only comment that I wanted to make. And thank you so much for the opportunity. Thank you, Chair.
Thank you very much, Advocate Vipon. That's appreciated. CEO.
Okay.
Yes, sir.
Thanks, Honorable Chairperson and the members. There are a few items that I need to clarify. The first one is the question that came from yourself, which relates to which phases have been approved. Phase 1 and 2 have been approved already. Then we are currently preparing to approach the Minister of Finance with regard to phase 3, which I mentioned the number of positions there. Then the next question, the chairperson of the regulator dealt with it with regard to the long term. The dates of 2022-23 and 23-24, in the readiness plan, there is a column that talks about the resources required. We have put the dates of 22-23, 23-24, looking at what is permissible with regard to the resources. But that doesn't postpone the action that we have identified in the readiness plan. Like the chair has given an example of the education and communication, the awareness campaigns. So we have advertised the post of an executive with the skeleton staff that will have. The education and awareness will be taking place. But to have that division properly funded, we are putting a 3 to 4 year period, because that is, what we believe perhaps over that period, we can have all the positions in that division funded. And we are also in the process of developing a communication and branding strategy that will also assist us to use different kind of platforms to render the communication and awareness services, not only the physical engagements. Then there was the question from member, I don't know if I'll pronounce the surname properly, Trachen, which relates to, yes, thanks. So which relates to where is the budget for office accommodation? We have put the office accommodation budget under goods and services because we are not planning to procure a building. And as our chairperson has indicated, the decision has been taken by the regulator to continue sharing accommodation with the Human Rights Commission. And we hope that we will also replicate this at provincial level by entering into MOUs with other Human Rights Commission and other organs of state in those provinces over the period when we are able to have budget now to establish the provincial offices. So, and that will really assist us not to have or to need a bigger budget for office accommodation even in the provinces. So it's part of the goods and services. Then the impact of COVID-19 on our budget. Yes, Honorable Chair, we were impacted during the month of April and May because we couldn't procure anything, let alone the positions that we had to re-advertise. But I can confirm now that from 1st June, we gradually returned to the office, the procurement of goods and services, including the filling of positions that were advertised before the lockdown. We have now moved, as I indicated, that between the 3 weeks of June, we have finalized interviews and for about 7 positions that we hope in a week will then finalize the offer letters and all that. And we have re-advertised the other 7 to 8 positions that are out in the media. So we are back on track in terms of spending. Then, yeah, I think those are the items I wanted to add. Thank you very much, Chairperson and the member.
Okay. Thank you very much. Colleagues, I think we appreciate the responses. Before I summarize, can I just check, Deputy Minister, is there anything you want to come in at this stage?
Chair, no, I'm fine, thanks.
You covered. No, thank you very much. I think it's very clear we need a bit more information, or rather engagement. But we push for time today, but I'm sure we will make space because this is a closed phase. These various phases of the operational plan requires perhaps some kind of input also from the committee, and therefore we will certainly make arrangements for us to very soon engage with you, especially when phase 3 with regard to establishment is approved, or if you have any difficulty with that, we will need to engage, and as well as the various phases in terms of the sections that comes into operation is very clear, very important. And then of course there's this MOU with the South African Human Rights Commission that we would want to go a bit more into detail, and that would be an opportunity next time. But let us thank you and the team for presenting today. We really appreciate this, because it's a new area for South Africans, in particular regulating personal information affects every South African everywhere, no matter at what level we are operating in this economy. So thank you very much. And this is a daunting task, but a necessary area of development for South Africa and Africa, as we have seen the implications worldwide when it comes to information security. So thank you very much, Advocate Lakula, and go well. The rest of us are off to the house. We are sitting at 2 o'clock today. Thank you.
Thank you very much.
Chairperson?
Yes?
Chairperson, we still have a presentation by the Human Rights Commission.
Oh, did I forget about them? That gives us how much time now? I hope all the members are still here. Let me just check who's still present. I'm just worried. Are we still a quorum?
I'm leaving in 7 minutes. Wilma here. So yeah. I don't know.
We are, Annie? Are we still a quorum?
Yes, Chair, we still have a quorum. We can proceed.
Okay. Can I just check with the Human Rights Commission? I think as one part of it, how long do they need?
Chairperson, thank you. Will really not take more than 5 minutes, I think, in terms of presentation.
Sorry about that. I almost forgot about you. How long is your presentation?
Will be very short. I will not take more than 5 minutes, just speaking.
Okay, let's proceed immediately.
Wrap it up very fast.
Sure.
Yes.
You can proceed.
Okay, thank you, Chairperson. I think the slides have already been sent to the committee, and I'm here with 3 of my colleagues, Fadla Adams, who's based in Cape Town, and then Tsepang Sibulela, who's actually assisting us in managing PAIA, and then, of course, Dr. Chanel Dufandibek, who's also my Deputy Information Officer. Basically, yes. Our presentation is just in 2 parts, Chairperson. One, of course, is what we're doing now as a commission in terms of PAI activities. And then the second part is basically our transitional phase. So very briefly, we'll continue the work which we're doing under PAIA. And then come the end of 30 June 21, when we're supposed to be handing over our work to Information Regulator. However, in view of the fact that our annual PAIA report can only come around 30 September, we'll then negotiate with the Information Regulator to extend our agreement, and so that we can actually do this report for them and not give it to them. Because if you recall, the reports from public bodies will only be coming at the end of May or March next year. And therefore, we should do this report ourselves. So basically, we'll continue, in terms of doing this work, and we'll cooperate with the Information Regulator. As it has been indicated, we have a memorandum of cooperation with them. We meet quarterly, and we've been working together for quite some time now. Unfortunately, when I rejoined the Commission in 2017, we had almost scaled down all the work of PAIA. So we only have one official, that's Mr. Tsepang Sibulela, on contract. And we've had to keep on extending his contract. So again, we'll have to extend his contract again at the end of March next year, so that we can actually facilitate this. Because one thing which I was very clear was that, we should not hand over to the Information Regulator a dead baby. So we'll try and keep the baby alive under IC until then. And therefore, we actually welcome these new developments, where at least now we know with certainty that there's a goalpost to head towards too. And of course, we are already neighbors, and therefore, at least the transitional phase will be much more easier than before, where we actually were working together now, doing joint operations with them. So basically, I'll leave it like that, Chairperson, and then maybe take a few questions from the slides. I just need to say, Chair, it's a very interesting journey for me, because in 2000, I was head of research, and we took over PAIA. And now I'm back again now, having to hand it over to the Information Regulator. So it's been a very long journey of more than 20 years in this process. A challenge.
Thanks. It seems PAIA only this part of
And lastly, of course, there are challenges which we will have to address. Our lack of cooperation with public bodies and other challenges. But I guess all those will be addressed during this transitional phase, so that at least, unlike us, when next year July comes, PAIA will be in a much better footing than it has been in the past, in terms of the infrastructure, in terms of the laws and regulations. Thank you.
No, thank you very much for that brief presentation. We can see the plan with regard to transitional period is in place, and we saw earlier the capacity is being provided in one of those phases to cater for this, for the volume of the work affecting PAIA at the Information Regulator. And I hope that would be probably one of the first one to be approved with regard to additional capacity on the regulator side. Colleagues, that was very brief there, but is there any question for the Human Rights Commission?
Just a comment, Chair.
Yes.
I just on a lighter note, I was just checking time against the presenter. No, 4 minutes. And thank you very much. And we welcome the presentation and also the move. Thank you, Chair.
Yeah. No, the slides are very clear in terms of the transition, that they have to manage between the regulator and themselves. So no, you're right. It was very short. Any questions, colleagues? It seems there's no questions for you, Advocate Chipanyani.
Thank you, Chairperson, and thanks to my colleagues for the slides, and also thanks to the colleagues in Information Regulator for the cordial relationships we were developing over time with them.
No, thank you also for being present today. We appreciate it. We apologize in terms of our time frames for this meeting, but certainly we will try to not put too many matters on the agenda at the next meeting, so that we give proper attention or more time to the Information Regulator and yourself. So thank you very much for attending. Colleagues, I think, is there anything else, Vuyani, at this stage?
Chair, we're done for the day.
We're done. Thanks to you also and your team for facilitating this meeting for us and the input. Colleagues, thank you. We will see each other in the house later. Go well.